Marilyn Tito Viviani, and I will be presiding today. And I would like to introduce my counselors, Counselor Juvaville,
Afternoon.
Counselor Ianella,
Good afternoon.
Counselor DePaul,
Afternoon.
and Counselor Duff.
Hi.
And I welcome you. And I will first make an announcement that I would ask everyone in this room to turn off their cell phones, put them away, so that we will be respectful for this important hearing. Now, I will ask anyone who is planning to speak to stand and take. You swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Okay, I will begin by reading the governor's letter. Dear councilors, I am pleased to nominate Sergio you know what? Tell me how to pronounce your name, because I don't want to be disrespectful.
Carvajal.
Carvajal, to the position of Associate Justice of the Housing Board. I submit this nomination for the advice and consent of the Executive Council pursuant to Part 2, Chapter 2 of the Constitution of the Commonwealth of Massachusetts. I am enclosing the nominee's resume for your convenience. Sincerely, Charles E. Baker. So I'm going to call on your witnesses in the order that you have given me. Oh, thank you. The first witness is the Honorable Janet Gould. You can sit right there. Right there. Sure. Thank you.
It's McGuigan.
I'm
But
sorry.
it's been 11 years since we've been spent
11
time.
years.
Yeah.
It's been 11,
It has.
and I should be able to pronounce your name. I'm sorry. It's an Irish name, and those are easy to pronounce. They mispronounce my name all the time. They say Devaney, and it's Devaney. So we're kind of even. Okay, welcome. Nice to see you.
Thank you. Nice to see you again as well. So good afternoon, everyone, to Councilor Devaney, members of the Governor's Council. As I indicated, my name is Janet McGuigan. I'm an Associate Justice here in the Worcester District Court. I was appointed in 2010. By way of just a little bit of brief background, I do serve on a number of committees in the trial court. The one that's perhaps most relevant today to my connection to Sergio is I'm the chair of the District Court Committee on Mental Health and Substance Use Disorders. I want to say first that it's a privilege to be here finally to testify today in support of Sergio Carvajal. And I want to commend the governor, the lieutenant governor, the JNC for his nomination to the Housing Board. As you all are acutely aware, the quality of our system of administering justice is determined in large part by the quality of the judicial officers that are appointed to serve this Commonwealth. Public trust and confidence in the judiciary begins with this process by which judges are appointed. And I want to thank this council for your tireless work for that. Attorney Carvajal is before this council because he is a highly qualified attorney, and he is qualified to serve in the Housing Board. I'm going to let the others witnesses testify regarding his Housing Court credentials and let the candidate himself speak about those. What I wanted to talk about is to maybe add a different perspective of the candidate for you and for your consideration. And that's his work in the area of mental health law. Over my 11 years on the bench, Attorney Carvajal has appeared before me in, I'm going to estimate, well over 50 matters representing mentally ill respondents in involuntary civil commitment hearings. So for those of you that may be unfamiliar with those types of cases, they're hearings where expert testimony is offered by the petitioner, which is usually a hospital, a psychiatric hospital. Sometimes there's an independently retained expert that will testify on behalf of the respondent. The patient, him or herself, may choose to testify on his or her behalf. And there are many other witnesses in these hearings that can include social workers, psychiatric nurses, mental health workers, police officers, members of the patient's family. The rules of evidence apply in these hearings. The burden of proof on the petitioner is proved beyond a reasonable doubt. So I tell you that too, so that you have a sense of how complicated these proceedings are. And they can carry, even over civil proceedings, they carry a criminal burden of proof. We in Worcester handle an especially high number of these types of cases in my jurisdiction because we have 5 psychiatric facilities in Worcester. We have 3 psychiatric hospitals and 2 hospitals with psychiatric units. Our largest psychiatric hospital being the Worcester Recovery Center and Hospital, formerly known as Worcester State Hospital. So you can imagine the volume of these cases is very, very high. There are days when I may have more than a dozen of these cases on my docket, and where the lawyers who do this type of law serve them, may have 2 or 3 hearings on that same day. Many of these lawyers who specialize in mental health law also handle matters in other jurisdictions throughout the state, including Bridgewater State Hospital, and we know this practice is significantly down there as well. So 2 very difficult facilities with high volume of these cases in Bridgewater and Worcester. As a result of this high volume of cases, I've had the opportunity to observe Attorney Carvajal capably represent mentally ill clients in some of the very, very challenging circumstances, especially over this last year during COVID, where the vast majority of our hearings were handled by Zoom. Attorney Carvajal is well skilled in trial practice. He knows the rules of evidence. He knows mental health law. He's a zealous advocate for his clients. He is always well prepared. He's very respectful to court staff and even to opposing counsel. In my experience dealing with Attorney Carvajal, he consistently demonstrates all of the qualities that make him ideally suited to serve as a judge in the housing court. First among them is patience, followed very closely by compassion. Most of our justice-involved members of the community are in very well-appointed lives when they enter a courtroom, no matter what court they're in. And when you add mental illness to that circumstance, you certainly have perhaps the most challenging population to represent. It's an awesome responsibility. It's one which Attorney Carvajal takes on a daily basis. He artfully balances zealous representation, compassion for his client's circumstances, the respect for the proceedings, the parties, and counsel, and the court. Attorney Carvajal will bring all of these qualities to the housing court. In addition, his prior work for legal services, his experience in housing court, representing individuals on both sides of the V, if you will, both landlords and tenants, make him uniquely qualified and prepare him well to understand the challenges of the parties that will be before him. It takes a special person to do the type of work that Attorney Carvajal has made his career of. The housing court in the Commonwealth as a whole will benefit greatly by his appointment as a judge. Through that housing court, I wholeheartedly support his nomination. I would respectfully ask you to confirm his nomination, and I want to thank you for your time to speak before you today.
Thank you. And don't be so long to be a stranger. I'd like to see you.
What?
Well, maybe council have any questions?
Thank you.
Thank you.
Thank you very much for coming. I appreciate it. Our next witness is Ron Backrack, attorney Ron Backrack.
Good afternoon. Good afternoon. Thank you very much. Again, my name is Rhonda Backrack, and I'm honored to be here to support Attorney Sergio Carvajal for nomination of the Associate Judge of the Massachusetts Housing Court. As you may know, Attorney Carvajal has been practicing for over 21 years, having become a member of the bar in 1999. Yet despite his years of practice, rather than becoming disenfranchised with the people in the profession, he's maintained his professionalism and civility throughout his career. I personally witnessed his civility during my cases against him, some of which, as you can imagine, were less amicable based on the parties involved in the disputes at hand. In fact, in our most recent case against each other, was one in which I never dreamt was going to settle because of the dueling personalities of the parties that we each represented. Like all other cases together, Attorney Carvajal zealously advocated for his client without the need for name calling, posturing, or bullying. Instead, he recognized his client's legal rights and remedies and worked with me within those parameters to find an amicable resolution to resolve the matter. By no means did he give up any of his client's rights, nor did he fail to put his client in the best position available. What he did do, however, was use logic, his vast legal knowledge, judicial temperament, and civility to conclude an otherwise very difficult and contentious matter. Put simply, Attorney Carvajal embodies the very definition of civility in a legal profession. He communicates with clients, he communicates with opposing parties and opposing counsel alike with courtesy, respect, and politeness. Likewise, I've also had the pleasure in watching Attorney Carvajal's non-discriminatory ways in handling cases. As an initial matter, as a woman, I faced my share of male attorneys who were outright dismissive of my input or my legal suggestions. That was never, and has never been the case with Attorney Carvajal. He's always treated me as his equal counterpart. Same can be said with how he treats all opposing parties, including the financial downtrodden. Specifically, I volunteer many hours for the Worcester Community Legal Aid's Lawyer for a Day program in Worcester. In getting these free legal services, these clients, many of whom are minorities, qualify basically mostly on income status, low income status. I've had several cases during my time of Lawyer for a Day with Attorney Carvajal. There's never been one case that I had against him when he was rude, offensive, even slightly against his clients. Rather, just like our other cases that we've had against each other in our private practices, he treated my Lawyer for a Day clients respectfully, all the while doing his job advocating for his clients. Again, Attorney Carvajal consistently proves through his actions that advocating for clients does not mean that one must be prejudiced, combative, rude, or confrontational, but instead that zealous advocacy means being prepared, knowing the law, and applying logic and the law to the facts and issues of the case at hand. I would be remiss if I did not mention that Attorney Carvajal's collegiality with members of the bar as well. Speaking from experience, he has been a sounding board for me regarding specific legal issues. Given his vast legal knowledge and expertise in land and patent law, he's also provided me with advice and mentoring at times in my own career. I've witnessed him offering the same assistance to other attorneys as well. Simply put, his very character is to educate, assist others, to really listen to them and offer his advice and expertise, all without being conceited and showy. For these reasons, I believe that Attorney Sergio Carvajal would be an exemplary addition to the Massachusetts judiciary. Thank you very much for your consideration.
Thank you for coming. Any questions? Thank you very much. Our next witness is the Honorable Rose W. Nielsen.
Thank you. Pleasure to be here. My name is Rose Nielsen. I was appointed to the Hampton County Juvenile Court in 2017. And first, I'd like to thank the Governor's Council for conducting my own hearing, and especially Judge Hershfang for supporting me through the process to the bench. It was certainly an experience. It's a pleasure and honor to serve on in such an esteemed position. I'd also like to thank everybody in attendance today for participating in a process that ultimately determines nominee's general appointment to the bench. I've known Attorney Carvajal since 2001, and we worked together as staff attorneys at Legal Aid. Sergio was senior to me, and I looked up to him as a mentor and a colleague during the 6 or 7 years we spent there. Sergio's always been a fearless litigator. I learned a lot by watching how he approached cases with practicality, while appreciating the nuances of the law and his client's individual goals. He decided in 2007 to leave legally and establish our own law firm. He knew he wanted to continue representing indigent and disenfranchised communities. Sergio's insight was crucial in developing a business plan and carrying it forward. He instinctively knew how to run a business in the law office. I trusted him implicitly with my money. That's a lot. and the staffing decisions. When we ran into any logistical challenges with the practice, he took it in stride and was able to weather the storm. Whatever challenge presented itself. He is a team player. He is a great law partner and a very hard worker. And he is the voice of reason during conflict or crisis in most situations that I've witnessed. I don't like to admit it, but I was always envious of his ability to compartmentalize the emotional from the actual when dealing with clients. He always demonstrated genuine compassion for our clients, but was able to keep the client focused on their legal objectives. And I'll give you just an example. When we were at Legal Aid, we had a client who was in public housing that had pretty severe mental illness, who prevented her from cleaning the apartment. And Sergio and I brought just some basic supplies and helped her get motivated to clean her apartment and prepare for a housing inspection. So it was a small gesture, but it was one that meant a lot to that particular client. He was always ready to lend a hand, to assist clients in reporting. He helps countless families maintain their housing stability by helping them manage their rental arrears or carrying issues that are often not in compliance with their lease obligations. Either by trial or settlement, he helped clients recover compensation for acts of housing discrimination. He was not afraid to take a case when he was on merit, and he was not afraid to try a case when he was assigned one, or when a client directed him to do so. He also lost the cases as litigators do, and he always did so with grace and humility. As time went on, Attorney Carvajal expanded his practice to represent landlords and property owners. He has also represented a vast spectrum of people in the community. He's represented children, elders, individuals, professionals, businesses, and banks. He's represented criminal defendants and municipalities, landlords and tenants, accusers and accused, healthy and infirm. As you've already been informed, he's practiced in courts other than housing, including district, juvenile, court, probate, family, and federal district court. This cross-disciplinary experience it's invaluable for a judge to have. Also gaining experience in the logistics of how different courts work. Clerk's office is definitely an asset for anyone sitting on the bench. Another advantage that Attorney Carvajal brings to the bench is his experience representing mental health clients that has a lot of patience and commitment to the most vulnerable populations. That not many can do this effectively without experiencing quick professional burnout. It's emotionally demanding, but this is what good lawyers do. The nature of an adversarial process contemplates that lawyers represent their clients' best and advocate for their clients' interests. They are client-directed, not necessarily driven by any particular ideology that doesn't bear witness to factual integrity. The government's counsel is verified. To the bench, she is undoubtedly qualified. And although he will be looked at as the smartest person in the room, but is humble, dignified. He's kind, he's compassionate, he has integrity, he's committed to his purpose. He is loyal to his clients and his charges. He's firm in his convictions, but also maintains an open. He's confident, he possesses a very strong work ethic, very important, he has a sense of humor. And he is Latino. His countenance and culture reflect many of the people served by the housing authority. On a more personal note, he is a strong support to his parents and his younger sisters. I've had the past, well, since 2001, watched Attorney Carvajal grow from, and his wife Laurel grow from a young couple to a beautiful family with 2 children and a beautiful Springer's family. I just want to thank you for your time and attention. It's an absolute pleasure to speak on Attorney Carvajal's behalf, and thank you so much for having me here.
No, thank you for your time and coming. Any questions from the councils? Thank you for your testimony. We appreciate it. And that concludes the witnesses in favor. Now, I will ask who is in opposition, and I will call on first witness, Chris Ross. You can sit right there where.
Please apologize, we're so sorry for being late and getting into the building is really.
Not easy in these times.
No, not at all.
And in fact, I get permission to get in the door.
Yeah.
Council outside. I don't know. Okay, why don't you start, Chris?
Thank you. So my name is Grace Ross. I'm at the pleasure of knowing many of you and talking with some of you as well about this matter. And thanks to those of you who have my condolences. I am the coordinator at the Mass Alliance Against.
Excuse me, it's your choice, but you can take off your mask in this council.
That might be easier for you guys to hear me. Okay. Sorry, as I said, coordinator of the Mass Alliance Against Predatory Lending. We have for the last 10 years or so done support work for homeowners who are fighting for their homes, dealing with foreclosure both before and after the purported foreclosure. And that in that role, we've provided people with emotional support, educational materials, and templates for dealing with court. I actually think that I've only met Attorney Carvajal in one circumstance, so I'm mostly reporting on a more general view of what I've been told and what I've experienced trying to support people in their court cases. And I'm especially here because Dolores Sweeney, who you have a number of her materials were sent to you, is, I think she would not be insulted by my saying that she's been sufficiently emotionally damaged that she can't appear. And we worked with her and we tried to support her to come, and it's just, I know it's still hidden because of people's shame, but the statistical reports show massive correlation between anxiety disorder and depression, losing your home to a foreclosure, as well as many other things, heart attacks and suicide. As a general context, we have not dealt with Attorney Carvajal nearly as much as we've dealt with many attorneys who represent banks in eviction cases after a purported foreclosure. And so we only have very limited experience. But what's most striking to me about that experience is that we only know of 7 members of the Worcester foreclosure team who have had Attorney Carvajal as the opposing attorney in their court case. Of those 7, one was represented. And she didn't feel like she had any direct experience with the attorney to report on what her experience was. But the other 6 all told us that they opposed his nomination. 2 of them are here. 2 of them couldn't make it for logistical reasons. It's a little hard with COVID going on. But it's extraordinary to us that 6 of 6 pro se litigants who've been opposed by Attorney Carvajal all expressed negative experiences, and I think I've gotten you materials from most of them, and we are missing one, I think. I was trying to get materials from them. So I think there's really 2 or 3 factors here. As you know, the housing court division is tiny. It's kind of in danger of being an inside club because it's so small. And you know that that's very
challenging to get impartial justice when a division of the court is so small that all the lawyers know the judges and all the judges know the lawyers. But it's a dangerous setup if there's going to be any kind of lack of partiality, sort of like, I'm going to report on this dynamic between an attorney on one side and pro se litigants on the other side. That's not a dynamic you're going to have as much in like land court or superior court, but in housing court, 25% of defendants are represented. 75% of plaintiffs are represented. And if a judge is not capable of being phenomenally even-handed, I mean, I think it must be one of the hardest judging circumstances in many ways because of that. How do you be even-handed when one side is unrepresented and the other side is represented, which is going to be most of the situations? And one of our concerns here is that the people who are trying to tell you that there are concerns are folks who are pro se. Right? And you're not going to hear from that very often. The Mass Alliance Against Predatory Lending is relatively unusual in that we're most of the folks who don't have lawyers. So it's a we see the world from a perspective that almost none of you will ever see it from in terms of dealing with judges, but you will be lawyers. So it's kind of limited in the world that you're going to deal with. It means that we've had to research and understand the rules of the professional code of conduct in relationship to the interactions between a lawyer and a judge or a lawyer and pro se litigants. Most of our folks are still bearing phenomenal shame, even though we have a historic rate of foreclosure. They're terrified, and they are fighting a sense that it's all their fault, even though the statistics show that there's no way it could be their fault. The American people didn't suddenly become incompetent around having mortgages in the early 2000s. And we have a historic rate worse than since the American Revolution. So it's not that somehow the people of the United States became idiots or irresponsible. That's not what happened. But it's the burden that most of our pro se litigants bear. So the first thing we ever have to teach somebody is to be able to speak up at all for themselves. So the dynamic that we see, and it happens in the hallways a lot, I cannot say that Attorney Carvajal is unique in doing this, but it means that as a judge, he's going to have in front of him numerous circumstances where a lawyer for a plaintiff has done exactly what our folks report Attorney Carvajal does. The code is incredibly unusual, and if you haven't read your way through the professional code of conduct recently, I encourage you to do so. Because under the issue of how you treat unrepresented opposing parties, it uniquely tells the lawyer exactly what words they're allowed to say, and that they are not to say anything but those words. Why? Because in our society, everybody respects the lawyers. Everybody recognizes an oath of office that you have a special moral and legal responsibility and that you actually are an arm of the government. You're an officer of the court. And so people assume, if you don't tell them otherwise, and certainly if you act like you're their friend, that you are being an impartial explainer of the law to them, even though they are pro se opposition to your client. And so it is not infrequent that if somebody goes to court in Worcester and the Worcester anti-foreclosure team, if they're a member of the Worcester anti-foreclosure team, the Worcester anti-foreclosure team has a rule and has had for about 8 years, no one goes to court alone. Even if somebody's going who understands nothing, you go with somebody. The reason is that if you go alone, you're likely to get pulled aside by the attorney for the plaintiff, and they're going to say two things to you in one version or another. You don't have a case. Sometimes they're much more graphic than that. But they're going to tell you, look, you're going to lose. And you've already lost your home in terms of the title. Now you're going to lose possession. You're about to get evicted. So they intimidate this person. And remember, in an eviction case and in a foreclosure, often the homeowner has experience that they can swear to that is material, that matters, and they are the only witness to that experience. So when they get in front of the judge, they're going to need to be asking to be sworn in to tell pieces of what happens. We even know in judicial foreclosure process, the homeowner has witnessed things that no judge has seen. And they have to be able to say what they know. So they are a witness in their own case. Probably anybody who's in the hallway with them in court also is a witness. Maybe they went to the foreclosure, maybe they witnessed a third party come to the house, claiming to own the property. So that person who's with them could easily be a witness as well. Why this matters is because the second thing they're going to get told is, don't go forward with your court case. I'll get you some money from the party that claims to own your home now, and you'll be able to move out. Now, if you're thinking of these folks not as opposing party, but as witness, which they actually are, you're tampering with a witness's testimony. You're saying you're going to lose, right? None of you would say to a witness for a case you're part of, who's standing in the hallway, none of you would go up to that witness and say, let me tell you whether your testimony is going to matter or not. And you wouldn't then say to the witness, and if you don't go in, I'll get money. That is what is done. And unfortunately, in the cases where Attorney Carvajal has had a moment to pull somebody aside in the hallway, he's had exactly that conversation. You have affidavits from some of the people for whom that's happened. And that gets even more complicated in the housing court situation because many of these cases then go to agreement. The agreements are made often in mediation. They do not take those sessions. You have no ability to get the record of what happened. And then you've been told you're going to lose, here's some money, let's go make an agreement. No one intervenes in this to say, wait a second, you're an equal self-represented, you're your own attorney, they're an attorney, you're equals in the eyes of the court in terms of your right to speak, in terms of your right to be heard, in terms of your right to make a legal argument. And so this can all happen without anybody intervening on behalf of the pro se defendant. I'm not going to go through the details of the affidavits you guys have, but let me say this. What happened with Dolores Sweeney is shocking, even in the context of the picture I painted. Twice, Attorney Carvajal arranged to meet her outside of the courthouse. I don't know about you, but if I was meeting somebody for coffee, I think it would be impossible for me, knowing that we're meeting about maybe trying to settle the case or something else, to say nothing except what the professional code allows, which is get an attorney. Why would you go have a coffee with someone when that's all the professional code allows you to do? You wouldn't, because how can you have coffee with someone without talking about that stuff? What happened was that she got given her the attorney's opinion that she would lose when she did a jury trial. People hang like a lifeline onto their jury trial. She was told he's almost never done one. She certainly wasn't going to win, but their jurors don't like it because you keep them there. And so they always rule against defendants. So she was prepared to do a jury trial. It's very hard for someone pro se to do it, but she had been through an entire court case. She had won once against the bank, and she was now coming up for a second round. She was prepared to do it. He convinced her that she was going to lose and she should give away her jury trial. He met with her again a second time, and I don't even remember all the details of that. It's in your notes, but this is devastating. Folks come back from something like this to the Worcester Foreclosure Team office, often a week or two later when they've kind of, gotten their tail back from between their legs enough to not be ashamed about what happened. And they come in and they go, what do I do now? Really, the only thing they can do in many of these circumstances is go in front of the judge and say, I made an agreement because I thought I couldn't win. I was intimidated. I was told by a lawyer who told me that he was impartial in giving this advice, and I need to undo this agreement. So we need judges, particularly in housing court, who are going to recognize the unique situation that a pro se litigant, a defendant is in, and be able to go, oh, you're right. The lawyer should not have said anything to you except, let's schedule the next hearing at this time, or you should get a lawyer. If they want to propose some kind of settlement, Obviously, the person should be given it. They should be told, talk to a lawyer. They should not be negotiating these things in a hallway or in a mediation where they can't even get the documents. But if we're going to have lawyers appointed as judges, we need judges who are going to actively understand what pro se litigants face, because 1/4 of defendants are represented, 3/4 of plaintiffs are represented. It is a setup that if you don't appoint judges to the housing court who really get it about what goes on for pro se litigants, there's no way they can give equal justice. And this isn't a personal matter. I mean, Attorney Carvajal may be, as well-meaning as could be. But if you don't come with the mindset that you're going to have to pay essentially more attention to what might go on for a pro se litigant, you cannot be even-handed. If you were in a court where 1/4 of defendants were represented and 1/4 of plaintiffs were represented, wouldn't matter so much. Yes.
Some questions, but this,
Yeah.
repeat,
Council Jeff.
thank you. You've told us this before, and we have a load of information telling us this, which I've read about 5 times. And I appreciate the work that you do and everything, because I myself have been in housing court and I understand it from a very personal point. I'm also married to somebody who signed a lot of documents they probably shouldn't have signed and lost their entire life savings because of it. But they took responsibility for what they did and paid their loans. So, one of my questions I want to ask, well, there's so much to unpack here. One, if you're representing yourself, you are then acting as your own attorney.
That's agreed.
Right, so the other attorney should have a right to speak to the opposing counsel.
No.
So in this case,
Excuse me, this is not a conversation back and forth.
no, these,
I know,
No, but I mean,
no, these questions,
I want to recognize your questions and I respect you, but I'm just wondering how do you want to do it? You want to answer the question or you want to finish?
questions and
All right, but
because it doesn't, I think, I really, otherwise this is just gonna, I mean, you're just repeating stuff we've already heard and we've already read over and over. So I need to,
Yes.
exactly, the public doesn't know, so that's why I want to ask. So there's a different set of rules for, the defense attorney when they're dealing with a pro se litigant. Is that what you're saying? So the pro se litigant has different rights than the other lawyer would have that would be represented?
No, it's the opposite. What happens is that.
Well, no, wait. Excuse me, Madam Chair, let me speak.
excuse me, she was answering
I
you.
know, because I wasn't finished with my question.
Let's not interrupt each other. She was answering you and you interrupted. Let her finish your question and then it's your turn.
You know what, I'm finished. I'm finished. No, I'm finished. I'm being interrupted by the chairwoman. What I don't understand, let me just cut right to the point on this one, in the Sweeney case.
Yeah.
What standing did Miss Sweeney have for this house? Did she own the house? Was the title in her name?
She would, so is the title in the name is the legal question. And so
It's a yes or no question. Was the title in her name?
it's not a yes or no question. I'm sorry, counselor, it's not. The way our registry of deeds works is that if you and I sign a deed, but it's invalid, then the deed that is valid in the registry will be the last deed that was signed. So it's
So you're
not
saying that the
straightforward
deed,
then.
you're saying that the deed of the house that she was paying the mortgage on was invalid? Was the mortgage in her name?
The mortgage was in her name and the deed was in her name. By
Okay.
the time we get to the end of the story, the bank claimed to have purchased at the auction. So that's why I'm not.
Was she paying her mortgage?
She paid her mortgage until she could no longer afford it. Remember, if you.
Okay, so she paid her mortgage until she stopped paying her mortgage.
Counselor, can I answer the
Yeah,
question? So
absolutely.
if you look at the materials, what you'll see is that she had a clearly predatory loan. The definition of predatory is when the bank gives you money without looking at whether you can afford to pay,
Correct.
but based on the value of the collateral. So if you read the materials, when she went to get this refinance,
the bank wouldn't give it to her until they found out that there was an additional $200,000 of equity in the house.
I've read that.
So this is the standard setup for a predatory loan. If you also look at her materials, you'll see that they went quite above their underwriting criteria for debt to income ratio. They literally cross out.
I understand all of that. I
No, but it's not
understand.
a question, it's not the right question because it's a loan.
Okay, thank you. It's not the right question. I'm finished. Thank you. No, thank you. Thank you. I appreciate your help. I appreciate your help.
Explain why?
I've read it.
Read it for everybody else's interest.
Okay, this is not the way that I would want to proceed,
No.
but, because I like to unlike councils and give them ample time. Well, so if you want to finish with the
I
other
would like to
thing.
finish this statement and then I'll go back to what I was going to say. So just to clarify, under Massachusetts law, if a loan is predatory, it was not underwritten for you to be able to afford to pay it, and it is actually considered void under the law. And you can look at the, I will send it to everybody, the Division of Banks, who's responsible for this, letter from 1997, and I could send you lots of them from the federal Office of Control of the Currency, et cetera. Whether someone has paid is sort of asking, after you get the lemon car, why, why are you not able to drive it? What's your problem? Or, after you've had the surgery and you've had sepsis, why are you not getting better? Our laws recognize that simply because you had an original contract, there could be something sufficiently wrong with that contract that it's unenforceable. And that's what we're seeing in a situation like Florida Sweeney, and the evidence is unfortunately in that huge stack of papers that we sent you to read. So, the issue here, of course, with Attorney Carvajal is not whether the original loan was predatory or not. The issue had to do with the treatment of Dolores Sweeney and Counselor Duff. The reason I raise it is because it's in the professional code for a reason. And if people would like me to dig up why the professional code is so careful about the way an attorney speaks to a pro se opposing party, I will dig up the American Bar Association's guidance if that would be helpful. It is out there. Okay, so that's the primary issue with that. The other issue, of course, is that because of the witness intimidation and the fact that in Sweeney's case, the bank had, for instance, never corrected its IRS filings, and therefore there was an issue about not reporting legally to the IRS, and a couple of other issues that are larger criminal issues. Sweeney had done 3 criminal referrals, one of which specifically focused on her treatment as a witness, both being told she could get paid off and being told she couldn't win and shouldn't bother to prosecute her case. That was referred directly to the city of Pittsburgh, and I think Sarah and people will deal with those issues. The only other thing that I wanted to say is that this is one of the messiest areas of law. I tried to get somebody, a pro bono bankruptcy attorney, around a post foreclosure case, and talked to 3 of the most respected attorneys in Worcester County, and they all said, I would not ethically take this case because foreclosure law is such a mess that I would literally have to learn a whole new area of law and could not ethically take on a pro bono case in this area. What that means is that our housing board is getting dumped all of these complicated title messes. That's not their job. They deal with possession, who lives in the property. Obviously, a precursor to that is who owns the property. But I have brought to your attention, and I won't spend more time on it because apparently I'm using more time than people want me to. But I gave you one example, and if any of you want more, I would go look for that. This one was relatively easy to find. But I gave you an example from the Figueroa case, where, which was one of the 7, of which 6 were pro se, that dealt with Attorney Carvajal as the plaintiff's attorney. And in his filings in that case, he characterized that history of a legal issue to the judge. And he specifically said that Massachusetts courts had never determined that the particular title violation voided the title. They've never decided that. He attached 2 cases to the case. I went and read them and went and looked up. One of them was a land court case, which had then gone to the appeals court, which he didn't mention in his brief. And the appeals court had reversed on exactly the issue that he said the Massachusetts courts had never decided voided a title transfer. So it literally was in the record. Now, there's no judge in housing court who has a clerk who looks up this stuff. And I've met with with 2 of the judges, not in ex parte meetings, in public meetings, where they've said that they have to learn from the lawyers in front of them what the law is. And that's why they don't listen to what pro se litigants have to say as much, because pro se litigants can't be trusted to know the law. So here we have a clear misrepresentation, a characterization of the entire history of the Massachusetts courts. The 2 opinions attached, one, as I said, I had to research the appeals court opinion, are not at all what they were characterized to be. And I assure you that the judge in this case did nothing but read his brief, because they don't have time to do the research, and they don't do the research, and we've been told they don't do the research. So the candor to the tribunal is absolutely critical, and it does not exist with this nominee. And it's very important because in housing court, he also won't have time to do research on most of these things. I think Kerman must have never slept. But I think the rest of the housing court judges are honest when they say they don't have a clerk. They cannot research all these issues. And if he felt it was okay to misrepresent this as a lawyer to a judge, I do not want to have other pro se litigants in front of him where he may do the same thing and assume that the lawyer's brief can be taken at face value. And he's already done that. And as you know, the professional code of conduct says that if you make a mistake and you find out later, you go back to the judge and you correct it. And none of this has been done.
So I think Councilor Julian Bill's going to go first.
Go over that issue again, that the representation of mass courts have never done what?
So, I had put it in my materials. So what he said was that, furthermore, Massachusetts courts have never looked at such peculiarities to void a party's claim to lawful title. And he's referring to where a third-party purchaser sets up a realty trust to receive the deed, but the realty trust does not exist at the time when they supposedly, the realty trust supposedly purchased the deed. And as you know, fundamental, much better than me, I'm sure, as a non-lawyer, but the fundamental principle of real property law of everything is that at all times, a property has to have a title. There is no such time period when a property cannot have a title. And it's, I don't even know where it comes from, because it's like 1,000 years old. But I have conveyancing language from I think 1040 in England. So it's been around forever. Anyway, he says that that courts have never looked at such peculiarities to void a title. He references 2 cases, the Needle case, where the land court relied on the deed in a situation where the entity that it supposedly transferred to did not exist. And then went up to the appeals court, and although the appeals court affirmed the land court decision on other things, on this matter, it reversed and said there was no way the title could have transferred in that situation. And the other case that he references, the Roth's case, the court actually went through some decisions a decision that went one way, a decision that went the other way, and then said in that unique circumstance, although the company that supposedly got the title had not registered yet with the state, that they did have articles of incorporation that allowed them to acquire property before they had formally registered as a corporation, and it was an exception because those articles already existed. So in fact, again, that case basically held the opposite, except for one little thing that they allowed uniquely in that case.
Could you give me the needle case, give me the needle case.
Sure, and I can also send you this outline that I did if you wish. It's Select Portfolio Servicing, VNEEDEL. So it's the spelling that'll mess you up, NEEDEL. And the land court case was in 2014, but you have to look up the appeal panel decision. The other is Roth, ROTH, apostrophe S, Wharf, WHARF, Co. The Judd, GJUDD, 108 Mass, 224, 1871.
Thank you.
Is that concluding your questioning? Council?
Yes.
Okay. Councilor, Burrow.
Thank you. How long have you known the nominee?
As I said, I've only met him in one circumstance, and it was would have been in 2019 in the Sweeney matter. I witnessed, especially his testimony. But as I said, I believe Sarah McKee is going to go into more detail about that here.
So you're probably not privy to this yet, but to public record, but we have numerous letters from to us by a judge of the presiding judge of the Southeast Court. We have letters written from housing chief specialist. I have a letter here from the community legal aid who talks about knowing the nominee for 20 years and all the good that he's done. People have retained him to represent, including the poor, the elderly, people with severe mental illness. I'm not going to read them verbatim, but it's fluent Spanish. And in one particular case, there was a boy who had to use a wheelchair to ambulate every time he moved. And attorney Carvajal and countless hours with the family explaining the complex cases, related cases in the state housing court, commission against discrimination, the U.S. District Court. He provided emotional support, compassion, and the young man tried to die with a litigation. But we have letters saying for 20 years, he has done a darn good job of what he does.
And
You're bringing to our attention, excuse me,
Sorry.
and you're bringing to our attention, maybe one or two incidents that you say that you didn't do the right thing.
So I'm bringing to your attention 6 of 7 incidents. The 7th, as I said, the defendant was represented. I think what my concern is, Counselor, my guess is that he's great with his clients. I mean, I didn't see everything you got there. I've seen some of them. My concern is that I think if you were appointing him to Superior Court, where he was going to have lawyers on both sides, then my concern would probably mostly go away. My concern is that there's a very unique problem going on here, which is treating other lawyers and judges in one manner, which is clearly respectful. They clearly feel like they can work with him, that he has a good manner for working with people, etc.
Well, let's not go there. I've been a lawyer for almost 30 years, and I've worked with lawyers who are respectful and don't treat people with dignity. But let me finish. Because we've heard a lot from you. You're at some point pontificating about what it's like in the housing board. And I've been there, and I get it. And sometimes people have to take responsibility for their actions.
I'm
And,
not talking about that.
well, I am, because I've seen both sides, where people sign notes. Sometimes I've seen people stay in their houses for 6 years, dragging it on and on and on and on before they get to the housing board. And at some point, someone has to pay the mortgage. If someone buys it at foreclosure, and they're not a person with means, and they can't afford to pay their mortgage now, then that person's the victim. But at some point, excuse me, I'm not done. But at some point, like, people have to take responsibility for their actions. I'm not saying that people haven't taken advantage of them, I get it. But I've also seen people take advantage of the system as well.
That's
And
a separate matter.
the other thing I want to talk about is, if you, as the attorney, sometimes we deal with people, all of us, there's probably 5 or 6 attorneys in this room, maybe 7 or 8 other people. But yeah, we deal with pro se litigants. And when you suggest that making a deal with a pro se litigant is somehow intimidating a witness, it bothers me. Because we deal with pro se litigants all the time. And if you have a personal injury case and somebody's on the other side and ready to go to trial, and you say, would you like to make a deal, we're gonna pay you X amount of dollars, is that intimidating to witness? I can't think of the housing board, you sometimes you just be straight deals, but that's called negotiation, it's not intimidating a witness.
You're talking about 2/3 of what I meant to get across. And
Yeah,
think-
I don't have any further questions.
Well, I think can get across, so what did you answer?
And I don't have any, there's no questions to you, so I don't need an answer.
Can I do the rest of the reply? You're interrupted.
So,
I
I
don't,
was not-
I don't have a question on the floor, Madam Chair.
Chancellor, I know that, but I'm chairing this hearing and I'm curious to know the rest.
Two things that I'd like to clarify. So one is that I'm trying to say that I think the concern here is.
Please address the chair because we
Oh,
still
I'm
have
sorry.
questioning.
I'm sorry, I didn't realize. What I'm trying to address is a difference in treatment of lawyers versus folks who are pro se, and that's where my concern lies. So of course, the letters from lawyers and judges, I'm sure are true, but that's not where our concern sits. Our concern sits about treatment of folks who are pro se, of which many people in front of a housing board judge will be. The other thing that I'd like to clarify is that I'm not discussing the question of whether somebody paid their mortgage or not. I'm discussing Attorney Carvajal and people's interactions with him, which I believe is what is actually in front of the council here. And that's what I'm talking about. And I did not say that simply having a negotiation with somebody where part of it is a settlement is the problem. I'm saying that the conversation starts by saying, you're not going to win this case.
Okay, I'm going to continue and I'll call on Councilor Duff. Do you have any other? Councilor DePaul.
I have no questions.
You have no questions. Councilor Iannello.
Yeah, very briefly, very briefly. How long have you known, Mr. Carvajal?
As I said, I believe I've only personally met him in 2019.
And when you met him in 2019, on one occasion, two occasions?
I was present for the lead up to and the hearing in Superior Court. And as I said, I believe that Sarah McKee has been addressing me.
Okay, so you've met him a couple hours altogether? I'm just trying to get a sense.
Something like
Okay.
that. But
In the couple, I understand, just my questions. You know,
I wasn't here to represent my personal relationship.
well, maybe that's the questions I want to ask. If you want to sit here, you can do that and run for office, but just answer my questions. They're not difficult questions. To me, the most important qualities of any judge, to me, is experience, character, and temperament. So my question to you, just your personal observations, not anyone else. Tell me your opinion of Mr. Carvajal's temperament. If you have an opinion.
I only witnessed him in court with a co-counsel, and as I said, I think you're going to get much better description.
I'm just asking you, do you have an opinion as to his temperament? It's not a trick question.
His temperament. From what I witnessed in court, he was calm, distant, which is a lot of lawyers are that way, that's fine. And did not accurately represent even when his co-counsel said.
And, okay. And your opinion as to his character?
My opinion as to his character is that based on his written materials, I do not trust his being honest about what he represents.
And his experience?
I don't have more experience than what I've reported.
Okay. I have no further questions.
Thank you. Well, first of all, about you, now, your position and who you represent to the public.
I'm the coordinator of the Mass Alliance Against Predatory Lending, and I also sit on the steering committee of the Worcester Foreclosure Team, which is the relevant stuff here, I think. I don't generally represent, I'm not a lawyer, and I don't generally represent on this issue very much at all. I'm really supporting other people who either are working to pass legislation or, learn about the law related to their cases. I coordinate a lot of the activities of the few lawyers who work on the side of homeowner as well. And I often am engaged in the legal research piece of looking up materials for lawyers and for the development and lay materials.
Well, you're well known for your service in Massachusetts. I thank you for that. This is the first time that you've ever appeared before the governor's council
Right,
to oppose a nominee.
correct.
That's very significant for you to, to put yourself out there to do that. Now, you're in court a lot, you observe a lot. Have you ever observed a lawyer who approaches, as a pro se, outside in the corridor and tells them you're not going to win, or you shouldn't go to a jury, or whatever, as has been testified with this nominee? I mean, is that the norm?
It happens too much, probably 65% of the time. There are some lawyers like, I forgot his name, who was unbelievably careful and very respectful, and I would never, ever have accused him of doing anything like that. So there is a way to manage it. I think it's not easy for an attorney to manage it properly.
Okay, can you detail some of the things that this nominee has misrepresented to a client, or, we have a letter here, and, and it's being questioned about, that Dolores Sweeney. But, I know there must be, very tragic cases. I mean, she had brother-in-law, sister-in-law, one of them since died, disabled, all of that, I understand that. I guess probably I'm concerned about someone going alone to court, and I'm a widow, and I know I would be, I would be fearful, and I'm really sorry, and I want to say it publicly, that this has affected Dolores Sweeney so much emotionally and physically that she's unable to even walk in here to testify. And that is a big concern to me. So, given that, I just wanted to know if a lawyer goes out in the hallway and to be friendly and says to this single person who, does not have a lawyer, that, don't go to, this is true, that he said, don't go to a jury, you won't win. That's a given, that's a truth, right? Well, I do want to tell you, I regret too, I got calls from people who were in opposition who feared to come because the reputation is in this administration, the council has never voted no on any nominee. So they fear that. They fear they come and put them out so publicly. It will hurt them and hurt their family. And it's going to be a judge, it's going to be a double whammy. So I do want to say that. I can't say their names. I will not divulge that, and I promised I wouldn't. But that doesn't help to not be able to put them forward, but I would never expose their names. So, so basically, you have looked at a lot of different cases. And why does this make you to inspire you to come
Right,
to talk on this one
right.
when you have been representing people for years and years, and we have to be an ocean? Okay, tell
Well,
me.
you're absolutely right that I never ever do this. I never show up and testify. I always
No, you don't.
encourage people to testify on their own behalf. That's absolutely true. And I think it's tricky to be in a place where there's somebody, or more, in this case, more than one somebody who felt that they couldn't handle trying to talk. To answer the original where you started, I would be more comfortable calculating and checking my notes to make sure that I'm completely accurate. But I know that one of the people that originally said they would come and then backed out early on, actually had come back from the court, having spoken with Attorney Carvajal, he's working class, solid kind of guy, Latino, who came back and was literally shaken and said, I understood everything. I can look at you showed me all of the documents. I've read all the stuff I was supposed to read. I was prepared to say something, but he was absolutely convincing that I will lose everything. They would go after attorney's fees, which at this point I've lost everything, can't possibly afford to pay. And I was like, this house is your entire life's work, right? Every cent you've ever saved went into this house. You're gonna walk away from that at your age. You're never gonna make that amount of money up again. Are you really okay with that? And he said, I have no choice. I'm gonna lose. I'm gonna lose. There's no point. And he was completely devastated.
So someone that's so vulnerable would take that as a friendly gesture of Attorney Carvajal to give them advice, wouldn't you say?
Some people
In that
have,
position.
some people have, not this guy, but he just felt that he had been told he was absolutely going to lose and they were going to go after further attorney's fees, and that he's like, he's a lawyer. He's a lawyer. Everything I've learned, I'm not a lawyer. He's a lawyer and he's told me I'm absolutely going to lose. I can't go forward.
Well, I see that Councilor Jubinville has another question.
Great question. How long have you been going to the housing court?
Well, long before the foreclosure crisis, I used to
Give me
be
an explanation, how long years?
35 years,
Okay.
What do you say, what?
35 years.
35 years.
Is there any legal representation or legal advice provided to people that come into the housing court process?
There is a lawyer of the day program on certain days, but there hasn't been, of course, during COVID and leading into COVID. But the lawyers of the day are not, unfortunately, versed in foreclosure related stuff. So they can give people good help on filling out answer forms, discovery forms, and things like that. But they would have no information one way or the other on foreclosure related cases.
Did Ms. Sweeney seek out the counsel of the lawyer for the day?
Ms. Sweeney actually had a lawyer for her whole first case that they won against the bank. And then after that, knew more about the case than any lawyer she could afford, which happens pretty quickly because there are very few attorneys on this side.
Well, sometimes people know an awful lot about a subject, and sometimes they know more than the lawyer that they hire.
Well, in her case,
There's
she
a
got,
reason why there's no representation. It is to put that barrier between the other lawyer and process.
absolutely.
So
There
just
is no,
take your answer to be, she did not seek legal advice from the lawyer today.
I doubt she did in those circumstances because she was already pretty far down the case. They usually help you with like initial stuff or filling out, like figuring out a procedural form, what the next procedural step would be, something like that.
You know, I can see the possibility with the person we go in to see the lawyer of the day and say, here's the situation, here's what's going on, the lawyer's telling me that I'm gonna lose, the lawyer's telling me that, I'm gonna have to pay legal fees or whatever else I've been told. Wouldn't that lawyer probably say, and I don't do housing, so I don't know much about the subject, but if I'm a lawyer for the day, I would certainly say, look, first of all, don't listen to him. He knows no more about what a judge is going to do than I do sitting here.
Right.
So it would have calmed her down significantly, right? And it might have even been that he said, well, with this kind of case, you should probably get some independent legal advice. Can a pro se indigent person in the housing court file a motion or orally move for the appointment of an attorney to
No,
assist?
we don't have civil Gideon yet in Massachusetts.
Civil what?
Civil Gideon is what it's referred to.
Oh,
But no, we don't have any appointment of lawyers in the House report. People have lobbied for it for at least 15 years that I know of. But your scenario is brilliant, and I've checked with people, but in her cases, there would not have been a lawyer of the day during those hearings, because the lawyer of the day is only there for that entry date when cases commence, which in Worcester is Thursdays.
so that means that their lawyer would be there for Mondays, Thursdays?
Yeah, so she wouldn't have had somebody she could have gone to, and I actually, it never occurred to me to have to tell people if they're gonna be in court alone to do that. I will suggest this in the future.
Okay, thank you.
Thank you. Well, I know being here 21 years, that this is the least known legal area that the council of the public knows about. I mean, I've been really reading all of this. It's been a month that I've been looking through all of this. And I'm no expert, but I do think there's a difference before, when you have a housing issue going before a superior court judge than going before a housing district judge. Now, am I right or wrong?
They're dramatically different. And one of the lawyers, in fact, the one that Sweeney had years ago, had said to me, I'd said, housing court is a great venue for people because so many people are pro se that the court's used to dealing with folks who are pro se, and the rules are minimized down to the very basics. Under summary process rules, there's only 13 rules, and the rules of mass rules of civil procedure, I think it's 85 or something, 90. And he said, yeah, that can cut both ways. He said, because the problem is the judges have so much discretion and the procedure is so undefined that if you're somebody who's good at looking up the rules, for instance, you're not a lawyer, you're good at looking up the rules, there isn't much guidance. And it gives he practiced in Superior Court and Housing Court, those are his two areas. He said it gives the Housing Court judges so much latitude. He said that, yes, it means that you can go in and not know much, but you also are really, there's so much discretion for a Housing Court judge that he said he thought it was part of the practice in Housing Court.
Well, to me, with all due respect, I what I was saying, but it seemed to me that a Superior Court judge would not know all the Mass General laws that was, pursuant to housing courts, that a housing court judge, wouldn't have the time to, as you said, look into all of those things. That's what I'm left with. To think
Yeah,
about.
and you're accurate, and I would reframe it slightly. Housing court deals with not the ownership of property, but the possession, who gets to live there. And because all eviction cases have now moved to housing court, they used to also sit in district court, and they rarely do now. You guys are going to have areas of law that almost no one knows, and we're worried about what that's going to do for appeals cases and in SJC cases, because the reviewing judges aren't going to know.
But I know you coming before us, you have more information in your 35 years that we have time to talk about, all the information you have. And all the councils are going to take this, your testimony and really thoroughly look at it. And we thank you for all your time and for your 35 years of, looking after people. So my next, the next witness is Sarah McKee. Now, Sarah, because of her disability, is unable to come, and she is on Zoom. Sarah, welcome. Sarah McKee. Now, Sarah is a prosecutor, fraud prosecutor, working for USA Interpol. And I understand, welcome Sarah, and I understand what you're doing is now that you're retired, is voluntary. You're not paid to do this. And so, so I welcome you, and we want to hear your testimony.
Thank you very much, Councilor Devaney and members of the Governor's Council. And thank you for the opportunity to testify today and for the accommodation of allowing me to do so from my home in Amherst. I'd like to make special thanks to Valerie McCarthy and Adam Costa of the Governor's Council staff for their very kind assistance with documents and with the technology. For more than 40 years, I have been a member in good standing of the District of Columbia Bar. I have been a career public servant. This included 8 years as a regulatory enforcement litigator with the U.S. Department of Energy. I was one of the 3 attorney core team responsible for most of the $1.25 billion in DOE's settlement with Texaco Inc. in 1988 for its oil overpriced charges. That money helped to insulate and lower the costs of heating for schools, nonprofit hospitals, and low-income homes. After a detail to the U.S. Attorney's Office in D.C., I joined the U.S. Department of Justice in the fraud section of its criminal division, where I investigated and prosecuted federal bank and tax fraud committed in the Northern District of Texas, Dallas Division. That was during the savings and loan crisis. I segued then into the practice of international criminal law, also with the Justice Department. This involved getting evidence from abroad for use in U.S. criminal investigations and prosecutions, getting fugitives extradited from foreign countries, and serving on DOJ and embassy teams that negotiated treaties with foreign countries for both purposes. I finally served as General Counsel of Interpol for the United States. My responsibilities at Interpol included verifying the legal and factual sufficiency of all U.S. requests for the famous Interpol Red Notices, coordinating with law enforcement and diplomatic authorities in the U.S. and abroad to set up arrests in international parental child abduction cases, and arranging for the return of abducted children to their homes in the United States. For all of these jobs, I swore an oath to protect and defend the U.S. Constitution. After I retired and returned to Massachusetts, Governor Deval Patrick made me his appointee for law to the legislature's Registry of Deeds Commission. In 2013, therefore, I swore a similar oath to uphold the Constitution of Massachusetts. And that is why I am testifying before you today. Our Massachusetts Constitution provides, quote, "It is essential to the preservation of the rights of every individual, his life, liberty, property, and character, that there be an impartial interpretation of the laws and administration of justice." That's in Article 29 of the Part the First. I believe that Attorney Sergio Carvajal has shown himself incapable, at least in my experience, of providing the, quote, "impartial interpretation of the laws and administration of justice," unquote, that our Constitution notes is essential to preserving our constitutional rights to our property. Property, of course, includes our homes and our rights to possession of them, whether as owners or as tenants. Here is why I believe that Attorney Carvajal is unqualified for confirmation to a lifetime judgeship on the Massachusetts Housing Court. I will discuss first his harassment and threats toward Dolores Sweeney, of whom you've heard. She's a retired public school teacher. When she appeared pro se representing herself in trying to save her family's home, and his lack of candor to a judge of the Superior Court in a hearing that I happened to attend and in which I was acquainted with this same case. I think that this is particularly important to the council. First, the information on Attorney Carvajal that you have received thus far concerns his conduct in housing court and district court. Perhaps, too, you have heard only from judges and lawyers. I am testifying to his lack of candor in a different court, Superior Court. This was before a judge who had no reason to be aware that Attorney Carvajal was misrepresenting the applicable housing court law, as well as certain facts of the relevant housing court case. You have received, I believe with my memorandum, a copy of an informal transcript of that hearing. um, um, along with what I sent to Governor Baker's chief counsel. Second, as to Attorney Carvajal's threats to Ms. Sweeney, he put one of those in writing, an email, along with certain misstatements of applicable law. So we're not dealing here with an oral representation, however credible it might be. And of what he has said, I'm dealing with what he has written. You have a copy of it. The email is the first page of the handout that I believe you received today. I will say that immediately after finishing my service on the Registry of Deeds Commission, I did start volunteering with the Massachusetts Alliance Against Predatory Lending, which you know is MAPLE for short. To go to the case directly, the first time that Webster First Federal Credit Union, and instead of calling it WFFCU, let's call it the bank, foreclosed on Ms. Sweeney, she had been, as Ms. Ross said, able to afford an attorney. And the housing court judge held that the purported foreclosure was null and void. Legally, therefore, it had never happened. A few years later, the bank foreclosed again, purportedly. Ms. Sweeney, as you've heard, could no longer afford a lawyer. In fact, at that point, she was legally indigent under Massachusetts law. The evidence that I saw showed that the bank had failed to fulfill the Massachusetts requirements for a valid foreclosure. Actually, the available evidence fulfilled all the elements of federal bank and federal tax fraud. I had prosecuted both of those crimes. I therefore put considerable work into drafting a criminal referral of the bank for federal bank and tax fraud. You should have received a copy of this referral along with my other materials. Ms. Ross and I, on Ms. Sweeney's behalf, submitted this criminal referral to the FBI through its Worcester field office. Thanks to the FBI agent with whom we were working there, we submitted this referral as well to the IRS Criminal Investigation Division. In Ms. Sweeney's second post-foreclosure case in housing court, however, the judge had decided that the bank was entitled to possession of her home. The lawyer for the bank was attorney Sergio Carvajal. The housing court had imposed a $20,000 appeal bond on Ms. Sweeney. This meant that she had less than a week to come up with $20,000 in cash. She couldn't do it. Instead, she decided to attack the housing court decision collaterally by filing a petition for preliminary injunction in Superior Court under Massachusetts Rules of Civil Procedure, Rule 60B, small b, 4. As some of you are doubtless aware, Rule 60B4 governs relief from a judgment on the grounds that the judgment is void. That is, it had no legal effect. As far as I'm aware, this was the first time that a purportedly foreclosed homeowner had made a collateral attack on an allegedly void housing court judgment by filing a motion for preliminary injunction in Superior Court. And this is perfectly acceptable. The reporter's notes to Rule 60B4 state, quote, "A party may obtain relief from a void judgment through an independent action to enjoin its enforcement," which is what Ms. Sweeney did. In a related connection, Timothy Sullivan, the Chief Justice of the Housing Court Department, citing a Supreme Judicial Court case nearly 40 years old, made explicit, as recently as 2017, that transfer from housing court to another court within the trial court department is appropriate if the housing court plaintiff's title to the property that the plaintiff claims to own is in Judge Sullivan's words, Chief Judge Sullivan's words, quote, questionable, unquote. The Superior Court is within the trial court department. Attorney Carvajal is presumably familiar with this administrative regulation of Chief Justice Sullivan. This is what gave rise to Attorney Carvajal's email to Ms. Sweeney. By the way, just to make clear, witness intimidation covers witnesses in civil cases about housing and other subjects, as well as those in criminal cases. And Ms. Sweeney is naturally, without a lawyer, a witness in her own case. But I am not asking you to find Ms. Sweeney credible, nor am I asking you to find me credible. Instead, you can look for yourselves at the evidence before you in Attorney Carvajal's email and ask yourselves, is this the conduct of a member of the Massachusetts Bar whom I can trust if I vote to confirm him to provide equal justice under law to all parties that come before him? Looking at that email, you will see that Attorney Carvajal says twice that his client will move to require her to pay its attorney's fees and costs first if, quote, the case does proceed, unquote, and then if she loses in Superior Court. He twice cites the relevant statute, Mass General Laws, Chapter 231, Section 6, capital F. The pertinent quotation on page 2 of your handout confirms that Chapter 231, Section 6F does provide for an award of attorney's fees and costs. I think it's fair to call this a threat. It amounts to give up your case, or I'll try to make you pay thousands of dollars that I know you don't have, and it's your disabled son or your disabled daughter-in-law. That is egregious enough. What's worse, if possible, is that this threat was simply false. Chapter 231, Section 6F applies only if a party was represented by counsel during most or all of the proceeding. Ms. Sweeney never had a lawyer for this second housing court case, or for her collateral challenge in Superior Court, or for any part of either of them. Neither did her son or daughter-in-law, who had possessory rights in the home that she owned. So this was a false threat. Attorney Carvajal knew perfectly well that he could never make good on this threat against Ms. Sweeney and her family. Here, I think it enough to say that his email's assertions, for instance, about the Superior Court's lack of authority to declare a housing court judgment void under Rule 60b-4, and saying that Superior Court, quote, states it will not reverse the judgment of the other courts, unquote, are not well taken. Superior docketed the case, accepted and docketed the pre-hearing pleadings, and scheduled and held a hearing. Also, the Massachusetts law librarians, at my request, ran a search for any Superior Court case that even mentions Rule 60b-4. They reported that there are no such cases. So I think we can take it as established that the Superior Court has never said that it would not reverse the judgment of the other courts. What I want to emphasize here is this. By threatening Ms. Sweeney with having to pay attorney's fees and costs, as this email shows that he did, Attorney Carvajal stepped over the line from zealous representation of his client into allegedly criminal conduct. Under Massachusetts General Laws, Chapter 268, Section 13, capital V, threatening or misleading or intimidating or harassing a witness, such as Ms. Sweeney, with the intent to interfere with a housing proceeding or a land proceeding is a felony. I think it clear from his email that Attorney Carvajal's intent was precisely to threaten, mislead, intimidate, and harass Ms. Sweeney into giving up her case by signing his accompanying joint stipulation of dismissal with prejudice, and by having her son and daughter-in-law sign it as well. The evidence, therefore, makes out the elements of the felony of witness intimidation. It didn't work. At least, Ms. Sweeney went through with the scheduled Superior Court hearing on her motion for a preliminary injunction. I was there. I thought that she presented her case clearly. The judge took the case under advisement. I understand that she nonetheless dismissed her case afterward, before the judge had ruled. It's enough to say here, I think, just a few words about Attorney Carvajal's lack of candor at that hearing. I discuss it more fully in my memorandum with citations to the copy of the informal transcript that you have. He told the court, falsely, that Ms. Sweeney had lost not only in housing court, but on the same issue in the appeals court. This really shocked me. He knew very well that she had not been able to appeal because she could not afford the $20,000 appeal bond, which she had just told the Superior Court judge about. So, contrary to his false representation to the judge, there was no appeals court determination against Ms. Sweeney. Furthermore, he sat silent while his co-counsel falsely told the Superior Court judge that Ms. Sweeney had lost not only in housing court, which was true, but in the appeals court and in bankruptcy court as well. Well, yes, there had been a bankruptcy case, but it had been that of Ms. Sweeney's daughter-in-law, and her home had never been an issue there. Attorney Carvajal also told the Superior Court judge that housing court has jurisdiction to determine title to real property. Well, land court does, Superior Court does, and the Supreme Judicial Court does. I'd refer you to Mass General Laws, Chapter 240, Section 6. Housing court, however, determines superior right to possession. And I've already cited to Chief Justice Sullivan's administrative regulation about referral to a different court if there's a question about title in the housing court. I would say that understanding the jurisdiction of a court on whose bench Attorney Carvajal has been nominated to serve is fundamental. In addition, he misrepresented the statute applicable to appeal from a housing court judgment if the defendant is a post-foreclosure homeowner, as Ms. Sweeney was. It is not Mass General Laws, Chapter 239, Section 5. It is instead Chapter 239, Section 6. This is entitled, quote, Condition of Bond in Action for Possession After Foreclosure of Mortgage, unquote. Section 5 applies if the housing court defendant was a tenant with a lease who had not owned the property. Section 6 applies when a defendant owned the home, has been non-judicially foreclosed or purportedly foreclosed, and might actually own that home still. It makes a difference. If Attorney Carvajal did not know the applicable law used in case after case in housing court, he is not qualified, in my view, to sit on the housing court bench. If he knew, however, and told the Superior Court judge wrongly, then for that reason, he is not qualified either. I will close by quoting from the oath that Attorney Carvajal, like a number of you, took in order to become a member of the Massachusetts Bar. It is at Mass General Laws, Chapter 221, Section 38. Quote, I solemnly swear that I will do no falsehood, nor consent to the doing of any in court, unquote. The evidence, in my experience, shows, I think, that Attorney Carvajal has failed to adhere to his oath as a member of the Massachusetts Bar, that is, as an officer of the courts of our Commonwealth. If you vote to confirm him, how well do you really think he would adhere to the oath he would take to become a judge of one of our courts? I thank you for your consideration, and I'm glad to address your questions.
Thank you very much for your testimony. I do want, before I call on my colleagues, to say that you sent a transcript from court that you attended at the Superior Court and explanatory documents. Every counselor got it, and you sent it to the governor and to the legal counsel Ross, and you asked that this nominee be withdrawn.
Accurate.
Before I call on my colleagues, did you get a response?
A response from Councilor Ross? I'm
Did you
sorry.
get a response?
I'm sorry. From
Can
whom?
you hear me? Can you hear me?
Yes, but I don't know from whom.
You sent a request to the governor to withdraw Sergio Carvajal. What was the response?
I got a response. I have to plead technological difficulties. I was never able to read it. I asked to have it resent, and it wasn't.
I don't understand. Do you understand?
Yeah. She wasn't able to technology get it, so she asked that it be sent, it wasn't sent there.
Okay, so you never got a response. Okay, all right. I don't usually be first because I'm a facilitator, but I just wanted to put that out. Okay, I'm going to call on Councilor DePaul,
I have no questions.
Councilor
I
Ionello,
have no questions.
Councilor Jubenville.
So let me get this straight. With regard to the email,
Yes,
you indicated there were misrepresentations in that?
Is your, excuse me, is that one?
Yes.
yes.
Yeah.
Okay. And was the misrepresentation the chapter 231, section 6F, which allows the assessment of attorney's fees and costs?
He accurately cited that provision. What he did not make clear was that he could never have got attorney's fees and costs from an unrepresented litigant.
I get that. I get it. Okay, thank you. I appreciate your testimony.
Okay, so, just ask you, I think your testimony was so thorough. I'm sorry that all the councils aren't here to hear it. This is a very important, hearing. First of all, have you actually met Attorney Carvajal or spoken with him?
I have not.
Okay. Okay, tell me your position on the Mass Alliance Against Predatory Lending.
It is, as far as the Mass Alliance Against Predatory Lending is an alliance of more than 70 Massachusetts organizations. For instance, the AFL-CIO, statewide, as well as local groups that fight illegal foreclosure. I would not have put 6 years of work, volunteer work, if I did not think that its integrity was unquestionable and that its expertise was worthy of my respect.
Okay, so what kind of things have you done for this, Mass Alliance?
A certain amount of research, a lot of editing, consultation, have drafted statutes. I have drafted and submitted amicus briefs in the appeals court and the Supreme Judicial Court. And I would say I'm a utility infielder for issues that do not require representing clients.
Okay, you testified that Attorney Carvajal has misrepresented the truth before a judge. Have you ever seen, in your experience, another attorney who said that?
I might have been in court sometime as a spectator when I did not know the case, and possibly that had happened. But in any case in which I was involved or in which I knew the case fairly well, I have never seen it happen.
You know what it amazed me about this whole thing is with your experience in Interpol and with all of the serious cases that you've had, United States cases, that you got involved in this attorney to ask the governor not to appoint him. And so that's going to be my last question, and I want to go on to our next witnesses. Because could you answer that?
I'm sorry, what exactly is
saying, with all your vast experience, have you taken on, big companies and agencies and representing the United States and representing Governor Patrick, and yet you're coming first time in opposition to someone going to the housing court in Massachusetts?
What I have seen is that the whole American system of justice depends on not only the legal competence, but on the honesty of lawyers and judges.
I think we can all agree on that. Well, I want to thank you for your testimony, and I wish you all good health, and thank you for coming first time. So we're grateful for that. So I'm going to go on to the next witness, who is Susan Ewans. Tell me if I mispronounced that, Susan. You did fine. Well, like, that's interesting because I have a daughter, Susan. So it's and Susan's from Worcester, and she's a resident, and from the Worcester Anti-Foreclosure Team.
Good afternoon. Thank you for having me in this afternoon. Unfortunately, one of the things I wanted to mention that I've heard during this last all these witnesses talking and so forth, the Honorable Jubenville is not here. I wanted to start and address something that he talked about regarding the lawyer of the day. I also see that we were also missing two others.
I'm very sorry, I'll have two councils here, but please continue whatever you were going to say.
Thank you.
Yeah.
All right, well, so regarding the my personal experience with the attorney of the day. So, and I understand that they're not there on a regular basis. I understand that they are available, but to a very slim extent. The lawyer of the day, you need to sign up. So you don't just walk in and say, I'm here, and you're gonna be able to see somebody within a reasonable amount of time. And then attorney, as Grace Ross pointed out, is going to do very fundamental things for you. That's what they're able to do. So in the situation that Mr. Jubenville was discussing regarding the attorney today, is you're approached in the hallway as an.
Excuse me, she was asking a question of you, so, okay. You see it.
I wanted to just expand on the attorney of the day. My own personal experience is, so if you're somebody like myself that is approached in a hallway prior to waiting outside the courtroom for your case to be called, there is virtually zero time for you to go downstairs, sign up, and wait in line if in fact that particular day there is an attorney of the day available. So I just wanted to clarify that on behalf of anyone in those situations. Okay, all right. I wanted to discuss my personal situation with, sorry. I wanted to discuss my personal situation with Attorney Carvajal. I was notified in February that he was representing a third-party purchaser, and that there was a case versus in Central Housing SWAT on February 4th. I was waiting in the hall, and I was approached by the gentleman who introduced himself as Attorney Carvajal, plaintiff for his attorney for the plaintiff, Long Hung, who I knew to be a man named Kyle, and Kyle only. And I knew that person to be Kyle because I saw him across the hallway, and he had come to my home on November 1st, unannounced, 7 o'clock at night, to my back door. Told me his name was Kyle, that he was purchasing the home. The following week, this was November 1st, he was going to close the mortgage on his behalf, that he had purchased the house from the bank, and that he was there to offer me keys. I advised Kyle that he may want to speak with his attorney because I was actively in Worcester Housing Court against Bank of America and also in appeals court, working to get my jury trial reinstated. His response to that was his attorney told him nothing, he knew nothing about that, he was sure that there wasn't any issues at all, and that his offer, which he never verbally made any monetary offer, would be good until that following Monday. And off we went, we exchanged phone numbers. I never heard anything from him via text, post office, phone calls or anything. The next thing I received was a notification to appear in court. So while I'm waiting in the hallway on February 4th, Mr. Carvajal introduced himself. He said that his client was willing to make an offer if I was willing to go to a mediator, and it would be an offer for cash for keys. I said that I was not interested in that. And then I went on to explain to him, I said, well, I know who your client is. I met him, but I only know him by his first name, which is Kyle. I knew that Attorney Carvajal did not know about this encounter on November 1st. But of course, that's not up to me. That's up to his client, whether or not he wants to explain this to him. So I explained to Attorney Carvajal what I had told him, that I had these open cases, that I advised him to speak to his attorney, and that he never made me a monetary offer, and then I never heard from him again. So what struck me about that conversation, he did say that he would speak to his attorney, and he, was very polite, very professional, went off back to his client. I mean, he said he would speak to his client, not his attorney. He would go back and speak to his client. Not less than 10 minutes, I would say, went by before we were called in front of for our case. So one of the things that stands out to me in that case, during that time of testimony in front of the judge, was that Attorney Carvajal specifically said that his attorney was a bona fide purchaser who had absolutely no knowledge that he should not, for any reason, purchase the home from the bank. And that stood out to me because just moments earlier, I had explained to him the very opposite. And his attorney, his client rather, sorry, I keep saying his attorney, his client failed to or did not, or as far as I knew, did not disclose any of this to him. I also had a sworn affidavit that I had sent to the appeals court on my behalf because I did get my jury trial reinstated. But that's neither here nor there. So that's the reason why I'm here today, is because not only do I know of all the other cases within the Wistrian foreclosure, I've also been witness as a spectator in courtrooms when other members have gone in front of the housing court. But my particular, and also within the encounter between myself and Attorney Carvajal, he was always very easygoing, very, nonchalant. Oh, you don't have to send me certificate of service to the post office. You can just email it to me. And it was always very casual, very friendly. I'm there for you too. Kind of give me like, oh, it's easy. Don't worry about it. Everything's fine. I'm lunch now. And I would always email him as it asked, but in that email, I was always indicate per your request, but I would also back it up with either an annual delivery, as you should with certificate of service for him.
Thank you very much. I'm going to start with Councilor Duck. Any questions?
No.
Councilor Paul?
I actually don't have questions. We had a chance to speak leading up to this, and I just appreciate your willingness to speak to your experience, which is no doubt a difficult one, and to be here because you feel so strongly. So I just want to.
Thank you.
That's right.
Thank you very much. No questions, but again, thank you so much to come in today. I know it's difficult, and I'm sure we all appreciate that. Thank you.
Okay, Councilor Jordan.
Two councilors said, I said, thank you for coming.
Thank you.
No, I thank you for coming, and I have to say again, this is the first time, I've been here 21 years, that we had people coming in opposition. That was the very first time. So it's not easy to put yourself out there, and I thank you for coming and taking the time.
Thank you all very much. Thank you.
Now, I have Christina McCarthy on the list, and I don't see her here. But all the councilors got information that she sent us. So I hope that you will read it. Where she is not here, is there anyone here that could talk for her that would just briefly now, that would know Christina and just briefly say something in a few short sentences?
I think her affidavit spoke for itself. She was planning to let you know that since that time, that Attorney Carvajal had taken himself off the case supposedly, but he's still the attorney of record, and she's constantly trying to figure out how to get to the actual attorney, the documents and stuff, and she doesn't know why, but that may be the court's fault. I don't know. I also will talk to her about giving all of them her phone number. She has had major medical issues with her daughter and disappeared today. I assume that. So I will get that to you.
Thank you very much.
Okay, I just wanted to say that all the councils for the public received this from Christina McCarthy, and she goes in detail in documents here, and goes on to 52 points. Okay, and I would just say the last point, 52. Okay, let me do, okay, if she talks about different things that he's done. Now, 50, she said, these are underhanded, dishonest, tricky acts. Our judges are supposed to be worthy of respect, even-handed, moral, and decent people. He set me up to be evicted because I would not have the right lawyer to contact at the last minute with the bankruptcy automatic stay, like I have a legal right to do. People who respect our laws, legal, precedents, the court's rules and don't try to take unfair advantage of pro se parties. And a single mother like this, who works really long hours, and is fighting to keep her kids healthy and safe. In her 52, I know it's long, I wish I could read each of the 52, but I know that I can't. 52, no one who believes in an impartial judiciary that is to even-handedly enforce our laws would make someone like Carvajal a judge. So that will be public if anyone in my office, if anyone in the council office, if anyone wants to see this. It is quite prolific. It really is. So very specific, 52 points. So that will be in the record. Our next witness, it was Wanda Karina Herrera, and she couldn't make it. Okay. One sentence.
I won't speak for her, but I'll give her number to everybody.
Okay, all right, that'd be very good, because when we are voting next week, we will read whatever she has to give her that due fairness. Okay, our last one is Steve Jenkins. Welcome.
Thank you for having me. Just for the record, I've only known him for a couple of minutes. Like a few days.
Take your time, you waited a long time.
Yeah. So I don't have to hear about 20 years or so. But in the short period that I've known him, I was wondering what was the next step. I went to court, had a hearing, told me can't follow through with the hearing because of go ahead and sign off some documents. So we had so the judge said continue to the next month. In between that time, well, the judge, she said nothing's going to change. That made me feel very uncomfortable. I just felt like I have no way out. So what I did in between March and April is that I called Mr. Carvajal and I asked him my alternatives. He didn't give me none of those. But he did ask me if I wanted to leave my home or advocate my home, and I said no.
Excuse me 1 second. Can you really make it simple for the folks on the YouTube? You said you went to court. I know, I think I know, but what did you go to court for? But there's a lot of people that go to court for what? If you could
Yeah, excuse me, could
make
you
it simple.
tell us the purpose?
Yeah, why were you in court?
So that.
That's what I
we
meant.
know.
Thank you.
Mr. Carvajal represented a third party said they bought my home, and so they wanted me evicted. So I went to court for a hearing.
Okay.
Is that clear?
Thank you.
Continue.
So, in between the time, March and April, the next court date, I did have a talk with Mr. Carvajal, and he told me, and he asked me what I wanted. I told him, I don't want to leave my home. I have a 13-year-old child that I adopted, so I have been taking care of him for the last 4 years. I didn't want him to leave. I didn't want him to be homeless, whatever you want to call it, whatever the situation would apply to him. But he said to me, I don't know, I'll get back to you. And called me a couple of days later and said that his client doesn't want me to stay in the home or pay rent, but you can stay for 3 months. And I felt I needed to make them payments and find a place to live. And I made that effort. The thing about it, it was just me, 1 bedroom. I had kids, so 2 bedrooms. People made it a little difficult when it's 2 bedrooms. So I kept, so when we get to court, Okay. It was on Zoom. The next hearing was on Zoom. Mr. Carvajal came first before we even had a meeting. So Mr. Carvajal bypassed the meeting, we bypassed the mediator. And the mediator read off what deals we were gonna make, me and him were gonna make. If you stay there for 3 months, you have to pay, $11,000. I made an offer. He said, oh, no, just 11. I was squeezing my fingers just to make that offer, but, so that was already written up, and by the time, the mediator came in, he read it off, asked me if I want to sign it, so, I mean, they electronically signed it, supposedly. But when I left the Zoom room, mediator came down, gave me the paperwork, and nothing was signed. And I thought I was, just dealing with my colleagues and my associates. I thought they let me know that it should have been written off by the judge. None of that happened. Just whizzed me right out the door. And I was on my own from that point. So me, thinking that nowhere to go, what am I gonna do? I thought that the whole process was kind of shitty. Because you got me out the door, you got me out off the list. But my concern was, how does Mr. Carvajal represent somebody who doesn't own a house and try to evict me from it? And those were the questions that came up after I went to the hearing. I didn't hear from nobody after that. But as far as focus on Mr. Carvajal, I don't know the process that we went through. I don't see him. I'm afraid for people like me who have to go in front of him. And his thought process like this quickly, I'm hurry, let me get rid of this guy. That's the way I feel. But we're not dealing with feelings today, I guess. But I was listening to all this great stuff you did. You need to stop. That's what I would like to. But that's all I have.
Well, we appreciate you coming, and, it's difficult to come and speak publicly. You always like to, it's easy to talk positively, but you're talking facts, you're talking the truth, and we appreciate it. I'm going to call on Councilor Jurgenville.
Good afternoon. Where are you from?
Mr. Mass.
Born and raised in Worcester?
Born and raised in Worcester, Mass. Mr. City Housing. Yes.
No further questions, thanks.
Councilor Reinald.
Yes, thank you very much for coming in. Help me out a little. You owned this home?
Yes.
Okay, and how long did you own, when did this happen with Mr. Carvajal?
June.
So, very recently.
Yeah, very recently.
And how long, and you lived there with your son?
Yeah, I adopted the son 4 years ago, almost 5 years ago,
Okay. And how long have you lived in this home?
since 2008.
2008.
Yeah.
So you bought the home and you had a mortgage on the home?
Yes.
And that's where I'm trying to get it. And Mr. Carvajal represented, in your case, he represented what, the bank or?
Third party, someone that bought, they foreclosed.
Go slow again, what's that?
The bank, they sent the bank foreclosed on my,
And were you aware of that?
I thought it was illegal.
No, but were you aware of the foreclosure proceedings? You saw them?
Was I aware of the foreclosure proceeding?
Yeah, the bank foreclosed on your home. I assume, and I could be wrong, you didn't make the monthly mortgage payments?
The monthly mortgage payment is right.
And how many months were you in arrears? How
I
many?
couldn't tell you. They stopped taking the money.
Okay, and when did
Because
they?
I noticed that there's people here, thinking, well, you shouldn't make the payments, you didn't make the effort. You guys are wrong when it comes to that.
Okay.
I made serious effort.
And when
I
did,
kept money in the bank, because when I got the house, I said 3 months of mortgage, so I'll never get behind.
sure,
But I went into the hospital, got sick, things happened.
oh, no question, I totally.
You're asking me questions like I made no effort whatsoever.
I didn't say that. when did you first stop paying the mortgage?
2017.
2017. And do you still live in that home today? You still live in the home? And have you made any mortgage payments from 2017 to now? So you've lived in this home for 4 years since you've stopped paying the mortgage payments. And help me out. What do you think you should be living? I'm trying to get a sense.
Yes.
Okay.
Because the contract that I signed
Yes.
said that if I got into any financial situation, that I would have a hearing. I'd have to sit down and we would negotiate. It says in their advertisement, we will keep you in your home by any means necessary, by any possible means necessary. I never got to sit down to renegotiate to see if I got, if I could work out a payment. They never gave it to me. They said that
When you say the bank.
the bank said that they live too far away. But, the reality is that when I got that mortgage, my bank was only 5 miles away.
Sure, no,
They use that. I get so angry with the way the system is going. I mean, how does the judicial system work for a bank? That's what I feel.
yeah, no, I
Don't
totally,
have to be true, but that's the way I'm feeling, being in the situation that I'm in.
no, I totally understand. So I'm just curious, what was your expectation? You stopped paying for, legitimate reasons, it appears, your mortgage in 2017. 4 years later, we're in 2021. What's your expectation what would be the ideal situation? Hold on a second. What would be the ideal situation for you? Do you acknowledge, number one, that you owe the bank the mortgage for the last 4 years? Or do you, I'm trying to just get that sense.
Acknowledging the fact, I haven't paid money, so that's.
Do you think you owe the bank that 4 years of payments?
I think I should be paying something. I ought to pay something. That's my problem. They won't take it.
Yeah. Yeah. No, I'm just curious if you think you should, because of your situation, I understand, totally understand that you should be paying less than what your contract said when you bought the house in 2008. You think you should be paying less?
Well, I think I should be paying less because I'm retired. I bought the house and I was working. I think it should be modified. I should have been modified to my retirement. Yes, I do.
Okay. All right. Thank you very much again for coming in. You explained it very well. I appreciate that.
Councilman Powell.
Yes, I just, 2 things. I want to thank you for being here, like the previous witness, to come and testify to your experience. And I think beyond the scope of this hearing, we're hearing a lot about how the ripple effect of housing insecurity and the difficulty that folks facing housing crises face navigating the court. So I think it'll be important to make sure we have housing court judges who are sensitive to that. So thank you for being here.
Sit down.
What bank or mortgage company did you get this loan from?
I got the first mortgage, I got it from Bank of America.
The first mortgage?
But they sold it. They sold it
I
to,
know. Yeah, that's what they do. They bundle them and they sell
yeah,
them.
then she started sold it to.
So you had B of A. And were you a first-time home buyer?
Yes,
Did you take a first-time home buyer class?
no,
Sorry, you didn't through again?
I am.
Okay, first of all, I know this is a very complicated, situation that you're in. So, Attorney Carvajal represented the bank, am I correct?
no, you represent the third party.
Okay, all right, so you have to explain this to me, how this works. So, you told me you got something that wasn't signed, that was supposed to be signed by this nominee. Tell me about that. What did that mean, that it did get signed to you?
Well, when I made an agreement, when the judge told me that I had no alternative, I made an agreement to take the 3 months. 3 months and pay rent till June 30th. And, documents from the media sections that we had were given to me, but they weren't signed.
And what did they say? What was the agreement that they made that wasn't signed? I just
The
don't.
agreement of paying them.
3 months.
Yes.
3 months.
Until
Okay, tell me, what part did Attorney Carvajal play in this at that point? No contact with you at all?
no.
Okay, so what happened? How were you prevented from not paying your mortgage? You said they would not accept
The
it.
bank, I was like prevented, I would send the mortgage in and it would be in my bank account the next month.
You know what, this is a point of information, and I don't usually do this, but I know that Grace is an expert, 35 years. Can you explain that about the bank, because we don't know?
Let me say two things. One,
We just have my, take this thing.
he has an affidavit that explains all of this, that with him, that he will sign and give all of you, so that it has more detail than what he said. In terms of the question that Councilor Ainella was asking about the mortgage, he has an FHA underwritten mortgage, and FHA underwritten mortgages have special protections that you pay, you spend extra time to get the mortgage, and with it come particular protections. FHA figured out decades ago that if you want to stop the foreclosure, the most effective thing is a face-to-face negotiation. It's written into every one of their mortgages. So if you fall behind, they have to, within 3 months, so that you'll have plenty of capacity to catch up, come and offer you a face-to-face negotiation. They have to send a letter offering it to you, and then if you don't respond to the letter, they have to show up in person to offer you the face-to-face negotiation. So what Steve, as I understand, is saying is that he reached out to them, they didn't work with him, and they didn't fulfill the language of the mortgage contract that requires them within 3 months to come and face-to-face offer him a face-to-face negotiation. So they violated the rules of the contract, and they are not allowed to foreclose if they don't hold that face-to-face meeting, which means they also violated that of the contract. But if I'm understanding him, and maybe you can clarify this, he actually was sending them checks that they didn't even have. So I think it was several levels. The last thing you were asking, and I think he was confused, I'm sorry, Counselor, from the way you phrased your question, because Massachusetts foreclosures are done by auction, they're not done in a court. Pro se litigants are always confused if that's referred to as a foreclosure proceeding, because to them a proceeding is going to court, but you don't actually go to court. They show up in auction. And so I think what Steve was trying to explain is they came, auctioned the house. The bank claimed to have purchased back. Of course, we know the auction was never back. Face-to-face meeting. So that's what he keeps referring to, saying illegal auction, and that and then at some point later, I think during COVID, this happened a lot, a third party purchased the title.
That was Attorney Carvajal?
And Carvajal represented the third party purchaser, and that's why they refer to as a third party purchaser, and that's the term that Steve keeps using. But so that's the situation that almost everybody who's been a defendant in a case with Attorney Carvajal has been in a situation where he was representing a third party purchaser who claimed to get the title from the bank, generally where the bank claimed to have purchased their own title at foreclosure. And that's how most of these cases have ended up in Attorney Carvajal's hands. And if you purchase a title as a third party from the bank, but the bank didn't have a legal foreclosure, what the Massachusetts Supreme Judicial Court said in the Lockwood v. Regis decision of 2011 is that the third party purchaser deserves recompense, but they're not to get it by taking someone's.
Okay, we could say the third party is Attorney Carvajal. I want to know what responsibility did the attorney Carvajal have, and what did he default in this whole thing? What was his improper?
It's actually in Steve's affidavit when he had the emotional space to write it all out, and I would encourage.
But we have to, this is a public hearing, I have to know.
I could read it.
All
I
right,
want me to.
because I'm not getting any interaction with the nominee with this.
I understand. So what he was pointing out to was that after the judge had said that things were not going to change, he had contacted Attorney Carvajal. Attorney Carvajal had a short conversation, said he would get back to him after he talked to his client. Got back to him and, quote, he said she's not going to go for that. She flips houses, she doesn't keep them. He told me I could stay until June 30th and pay rent, but he never made a specific offer. The case was continued to April 5th, 2021. When I got on Zoom, on the third button, Carvajal said, we don't need to go in front of the judge, so we want a mediation to finalize our agreement. I was never given a chance to say anything. I didn't agree with that. Next thing, I'm in a Zoom with the housing mediator, Tim Dunn, and Attorney Carvajal. Tim Dunn said, you have an agreement. Again, without my talking, Attorney Carvajal said, yes, here's the agreement details. It was already on paper. I had never seen. Tim Dunn turned to me and asked me if I agree with the agreement. I said, yes. When Tim Dunn said, I'll mail you a copy, wait, are you in the courthouse? I'll bring you a copy. I felt threatened and defeated at this point. I didn't have legal representation, nor could I afford a lawyer. I was participating by being in the courthouse Zoom room. So Tim Dunn came saying he's giving me a copy of the agreement. I had never gotten to read it, and I had never signed it. I was never offered to go in front of the judge and have the judge affirm that I knew what the meaning of all the words in the agreement were. After leaving the Zoom conference, I was overwhelmed with fear and very distraught, and I'll skip. As he's talking, well, my first thought was, what do I say to my 12-year-old adopted child? Feeling lost and discouraged, I held off from saying anything for weeks. When I finally told him by stating that we may have to move, he said, no, God, Dad, that would mean that we're poor and we'll have to move to an apartment. He had many concerns, grades, school, friends, visit with his mother, etc. I wondered about the court process and how could they sell my house when the judge never signed off on the decision. When I finally pulled out the actual agreement, I found out it was never signed by anyone. The judge never signed off on it. So I understand it's not the same thing as a judgment. That I said I had agreed to give away my life, that is my claims, to mine and my son's home. And that's what he found out later when he had read.
Counselor Idelli.
Yeah, thank you very much.
Thank you.
I know nothing about the housing court. The last time I was in the housing court, it was in Judge Paul Garrity's session. I was a custodian, okay? I've never appeared, and nothing at the housing court. So see if I have it right. Steve, you explained it pretty well. He had the issue with the bank and the bank didn't follow up with the requirements that you talked about. So the beef, the way I look at it, is with the bank, they didn't have the face-to-face meeting, they didn't do this, the bank screwed up. So at that point, the bank forecloses, auctions off the property, this third party buys the property.
I think that the third party actually bought later, right? There was an auction, the bank bought back, and then.
And the third party eventually. And the nominee represents the third party. And these third parties, are they just private citizens?
They vary.
Okay.
Sometimes they're LLCs.
Okay. I'm just surprised how they all come, these various people, how do they find him? I don't know, maybe he specializes in this, but, okay, I get all that. So obviously, just to tip off Attorney Carvajal, I'm definitely going to ask you, sir, to sort of explain this, okay? I get that. So he has a beef, or looks like the bank and him didn't get together. Obviously, I don't know. I don't know if the bank sent them letters. I don't know if the bank went there. I understand what this gentleman, is saying. But I guess I get it, times are tough, I get it. But I guess my point is, you take a mortgage, you owe money, I know what you're gonna say, but don't you have to pay the more, I'm gonna ask him this too, like, at what point is it 2 years? And hold on one second, I didn't finish my question. This case is 4 years old, he hasn't paid, I know he put money aside, but at what point do you think, you know what? It's 5 years, it's 6 years, it's 10 years, it's 20 years. At what point do you think the bank, the third party, it's time, unfortunately, you know, because the owner of the property, I know that, but the bank has they have their bills too. I know that we're not too concerned, nor I am, about the bank, but when is enough for the bank to say, hey, listen, it's been 20 years, 10 years, that's what I'm trying to get at.
May I respond?
Yeah, I asked you the question, yes.
The problem is that once you fall behind, no matter how much you try and do something, they won't take the money. I think that's what Steve was trying to tell you, is that the homeowner ends up in a position where they won't take the money. So sometimes the homeowner doesn't try and pay something, but if they do try and pay something, they literally don't take the money. So you're stuck. You're not an actor in this situation. You're a respondent, I guess I would say. So once they decide you're in default, unless they negotiate something with you, which our laws actually in Massachusetts require under 244-35B, you can't get out of the situation. And some of the homeowners who know enough to do it will take those facts and put them in the registry of deeds under an affidavit. And then third-party purchasers should be aware because they've put an affidavit in the registry of deeds, if you know how to do that. Now in Worcester, Steve couldn't do that because our register of deeds, unlike the rest of the registers of deeds across the state, pretty much, there's one or two others, will not take those affidavits. So if you're a homeowner, you try and pay, you can. They won't take the payment. And in Worcester, you can't even warn a third-party purchaser by putting an affidavit in the registry.
My guess.
They shouldn't purchase. And under Massachusetts law, a title only clears under operation of law 50 years later.
Okay, now I get all that, trying to make it simple. So are you saying to me that someone like Steve goes in front, at some point, Steve had to go in front of the judge at some point, way back when they evicted him? Had to.
Yeah.
Okay, but way back when, I assume he's not paying his payments to the bank. I mean, was the court involved? And I guess my point, the court was never involved. So how?
No, there's non-judicial foreclosure, and so
Okay, so
literally don't ever get in front of a judge.
you never get in front of a judge. Okay, so a judge is never involved at this point. There's no, you have so much more knowledge than a lot of us. You make it a little, my father used to say, treat everyone like they're 2 years old when you explain it. You just know too much. No, make it simple. Sometimes, you say chapter 206, it just like goes over everyone's head.
I got it.
No, but hold on. So when someone's behind in the mortgage, whatever it's 2, 5, 10 years, the court is not involved.
Right, the court is not involved, and in fact, it's the reason I was gonna add what you were saying, is the reason there's so much pressure on the housing court judges is because in our non-judicial foreclosure system, you don't have a right to court in a foreclosure. The first time you have a right to court is as a defendant in an eviction case. And where a housing court doesn't have jurisdiction over title, we're in this conundrum situation where you're now in front of a judge who doesn't have expertise in real property law, doesn't even know kind of the most critical elements of running a case for title because they don't run them. And yet somebody like Steve, that's where he is. And up until you're in housing court being evicted, there's no way to force a response from the bank at all. You can call the governor's office, you can contact the Consumer Finance Protection Bureau, but literally no one can force them to talk to you. So you can be in the house for 10 years, trying periodically to get them to talk to you, and you literally, they won't take your money, and they don't have an obligation to talk to you.
Yeah, thank you, and just a question, Steve, I'm just curious. Since 2017 to the present, well, I was gonna say I assume, but did you write letters, back in 17, back in 18?
No.
To the bank? In other words, do you have a paper trail? Hey, listen, I wanna meet with you, I've got financial problems, I wanna pay you, but I can't, I have a son who lives, did you write them letters?
No, I did not. They stopped communicating with me.
They what?
They stopped communicating with me and then, but I was concerned that, you know, if there was an issue, I had $18,000 in escrow. You couldn't.
No, I understand, but I didn't know if you sent them letters and you have copies of the letters. Okay, thank you.
I think honestly, Counselor, that people fight really hard up until the election. They call, they write, they try and reach their, you know.
No, I understand. I didn't know if he had any of the letters back in 17, he didn't write any of them.
Well, right, we'll look for, I think he will have stuff pre the auction. The
No,
auction,
that's what I'm talking about, since he stopped paying.
right, the auction feels like the death knell.
I understand. Thank you very much, appreciate it.
Councilor DePaul had raised his hand first.
Yeah, I just have a very short question that came to my mind, what I just heard, and I want to make sure I understand. So I think I'll address this to you, Ms. Russell. The affidavits you were speaking of, that Worcester won't let, it doesn't allow to be, is there a term for those that that if I said them, someone who practices?
They're called, sorry for chapter and verse, but they're called chapter 183.
I want chapter verse. Okay.
Chapter 183, section 5B.
Yeah.
The registries of deeds guidance only allows a very limited number of types of documents that will be recorded.
Mhm.
And that's the only one for a standalone affidavit, and it requires specific things, but our folks can meet those things. They're doable.
Sorry, could I follow up on that? So why, I realize this is tangential, why is Worcester?
We don't know. The previous register of deeds, who you may have known was there forever,
Correct.
was considered very middle of the road, not a risk taker. But he learned about this process and he opened the registry for people to file deeds. His predecessor came relatively recently, it's not to report. Sorry.
Yeah.
Councilor Dunn.
So the Register of Deeds comes under the Secretary of State's office, so that's who you should be talking to about that.
We have,
And as far as the, your mortgage payments, which they refused to take, did you then take that monthly money and put it in an account, in an escrow account?
Yes, I had been in escrow account for a while. For a while, I be totally honest. Things got a little tight, I used some of it, but the bank had $18,000 in my hand.
So that escrow that the bank is holding is different than you being able to prove that you were trying to pay them. If you had taken the money, your monthly, say your mortgage payment was $2,000 a month.
Yeah.
Which I'm gonna guess it probably was. If your mortgage payment was $2,000 a month, even if the bank refused to take that money, if you were monthly taking that money and putting it in a specific escrow account and notifying the bank of it, that you were doing this, you know, you would have a better recourse. It seems that the beef that everyone here has today is with the banks in the banking system. And I get that. I hear it loud and clear. I know it. I've been in housing court. I understand that intrinsically. I believe that everyone who buys a house in Massachusetts, a first-time home buyer, should have to take a first-time home buyer class. Because you are a responsible adult signing legal documents. And everything you sign says, this is a legal document. If you do not understand, consult an attorney. Every single real estate document says that. So I get it though. You're excited, you're buying a house, people get caught up in the moment. You bought at the height of the market, 2008. I don't know who was guiding you through this. If you were using it's the difference between using a local bank and not using a local bank. I mean, it really truly is. You didn't have somebody that you could go talk to. because your mortgage had been bundled and sold. And that's the type of thing that you would have learned if you had taken a course that if someone had encouraged you to do, maybe you would have done it, I don't know. But I think it's important that people do those things, because I just hear the story over and over, and the beef seems to be with the bank. I don't know how you can hold an attorney who's doing his job responsible for what the bank does, but that's a different issue. I hear you loud and clear, and I'm sorry for the trouble that you've been through. I've seen this happen over and over again, where people can't speak to banks because they're working with, you know, a conglomerate. They're not working with a local bank. That's the difference. It really is. And unfortunately, if someone had educated you before the whole process, you probably wouldn't have ended up in this pickle. So.
Yes, did you want to speak?
I don't know the proceedings. Is it okay if we
Sure.
speak at this point? Thank you so much.
You need a mic, though.
Okay, thank you so much. I'm just a little confused. I thought we were here specifically for what, Attorney Carvajal did or did not do.
That's true, that's
And
what
we continuously, I continuously hear, councils keep talking about how much was your mortgage, who was your mortgage, why did you pay your mortgage? What's it? We're constantly talking about that. And what an individual has done or not done with their bank and their mortgage. I don't have any idea what it has to do with the nominee of an attorney to be a judge based on what they did in their at the time that they were hired by a plaintiff to represent them in court. I don't understand whether you have an FHA or a regular mortgage, whether you're Bank of America or with the credit union down the street. I do not understand what any of this has to do with it. And so I just wanted to clarify why there's so much talk about it.
comments. I think, you know, what I'm seeing is that, you know, putting myself in your place, Stephen, you know, you trust, and someone's gonna sign something, and that's gonna be a document that's going to be official, and they don't sign it. And you've had no communication from what I'm hearing from the attorney who was the third party. All of it, to me, is, that he was left out in the cold. He wasn't told what he had to do. And then when he tried to, they don't accept the money at the bank. So, I mean, you know, I don't think you have to take classes or whatever. I think there should be laws to protect us. I'm not gonna take a course to find out. I mean, when I bought my house, you know, you trust that the bank is gonna do the right thing. The third party, I don't quite understand this, to be honest, how, Attorney Carvajal. And so what I was going to ask Steve, what relationship did you have with Mr. Carvajal? What did he do? When did you approach him and say, hey, look, this is wrong, I want to pay, I've got escrow? I don't have those answers, okay? So I appreciate what you're saying, I understand.
Well, his only concern was for his buying that conversation would not come up.
Okay,
When I did ask him, what can I do? Crickets, he never, it was like,
So-
but the reality is that he doesn't have to say anything to me because he's representing the plaintiff.
Correct.
But the way people are talking about how outgoing he could have told me I had alternatives. You know, you don't have to say that. You don't have to say what they are and what I can do, but tell me I had alternatives.
we know what's coming to my mind is that, you know, I've got a lot of testimony from people who will call me, and then he talks in the hallway and nice and says, you know, you shouldn't do this, you're not gonna win, you're not gonna lose, but he never, you know, came forward to you to advise you right or wrong. So there was no communication. So you're here now. Tell me specifically the reason you're opposing Attorney Carvajal.
The way the process went.
Okay, so tell me
I don't.
what you feel he could have done for you. I know he's not representing you, but what could he have done to make sure that the documents you got was signed? Did he have something involved in that he should have had that signed?
Yes.
Okay, so that's where the law lies, right there.
That's,
That he should have looked at to make sure the documents you got, and you never did, or you got them unsigned,
I'm sorry.
and that you never had an opportunity to go to judge, you had no opportunity to talk to anyone. So it seems like this was very one-sided. And, you know, I don't have to be a rocket scientist to know you were wrong. You were wrong. And I appreciate you coming to talk about this because, what do I know? But I feel that he had a responsibility to make sure what you were sent was signed by people. I mean, you know, when you buy a house, you have to sign it. I mean, you have to sign everything in life, you have to sign. So that's where it lies. I don't understand why this nominee would do that. That's unfair. And I know there's laws that don't allow that to treat someone like you. But I would be in the same position as you are. But my whole thing is that you had money in escrow so that you were able and willing to pay the mortgage, but you were prevented because of all of this misjustice, really. Would you say that?
yes.
Yeah. Well, you know, I don't know where you go from here. I wish I could advise you. I don't know. Maybe you could, what, you know, one of the lawyers here could talk to you about it. I mean, I would think Secretary of State, they have a line that you can call. There's got to be some way that you can get some help. There's court advocates or whatever. But I don't know now. I mean, you're living in the house, and so you just go day to day, and you're going to adopt his son, and he's concerned staying in his school and his home. You know, my hat goes out to you. I am so sorry, and I have no ability. But you know what? You brought justice here today to talk about what happens to someone when they don't have a lawyer and they're at the mercy of an attorney, third party, and the bank. And so I wish you all, you know, good health and work this out. If I ever can do anything, I would be happy to. I never talk like this in public, presiding, but it is upsetting to me that you're in this position, and especially with your son. So is there any other closing statement that you would like to make?
I just have one last one.
Okay,
Thank you. Again, thanks for coming. I will ask our current attorney Carvajal, you know, does he have an obligation? Does he have an ethical obligation to give advice? Let me just finish. I know what I believe, but we will ask him. I don't want, I think I know the answer pretty clearly, but that's really the question here. He may have no obligation whatsoever, none, but we'll ask him. Let me just finish, excuse me, to give any advice whatsoever, because again, we'll ask him. His client is so-and-so, he does not represent this gentleman, and we will ask the attorney when he has a chance, or he can address it in his opening, if he
I
wishes.
agree absolutely with you, Counselor, but my whole point is, and that's the question we have to have answered. What part did he play in that document that was never signed, that was sent? And that's where it went south. That's where it went wrong. Perhaps if that had been signed, it would have been a whole different story. He wouldn't be here and he'd be happy with his son. So that's where it goes back to. You don't send documents to anybody when it's not signed, because it's not legal. It's not legal, but if you don't have your signature on it. I mean, you know, you get a Discover card, if you don't sign it, you're not gonna be able to use it in the store. Your signature is used by everything in life. That was his life. That was his home. So that's the question that we have to go back to. The document that wasn't signed, never saw a judge, and that was the end of it. He had no recourse. Anything you want to finish, you just say.
Thank you.
Okay, thank you for coming. I appreciate it. Yes. Judge, I'm sorry. Could you sit down again? There's a question. Oh, I
I
thought,
said, thank you for his testimony.
I'm sorry.
To hear from this witness.
They pointed to you.
Thank you very
Okay,
much.
now that we've concluded all our witnesses, I'm going to call on you, our nominee, attorney, Carvajal, if you would like to make a presentation.
Thank you very much, Councilor Devine. Good afternoon, as you have heard, my name is Sergio Carvajal. Justice Senator O'Connor once said that we don't accomplish anything in the world alone, and whatever happens is the result of the whole tapestry of one's life and all the weaving of individual threads, one to another that creates the sentiment. In that sentiment, I want to extend my thanks to Governor Baker and Lieutenant Governor Polito for my nomination. I would like to thank all the members of the council for allowing me to speak to you and have this opportunity to have myself present, my witnesses and the witnesses who came speak and provide you with information about the housing board. I'd like to thank Justice Jen McGuigan, Judge Rose Nielsen, and Attorney Backrath for coming here and giving statements in support of my nomination today. I also want to thank my wife Laurel and my sons, along with my parents and my sisters. Considering where we began our journey, we have traveled this road. They have traveled this road with me up and down, and we've endured this process. My parents, my wife, my family, my friends, and my colleagues have been a great source of strength and solace in this endeavor. My parents have been provided me with lifelong love and support. And at this stage, it is a great honor for me to be considered for one of the most important roles an individual can hold in government, just to be a judge. I also like to give some thoughts to a friend of mine, Attorney Greg Angelini, who is a dear friend who passed away recently. Attorney Angelini was my mentor. He was extremely supportive to me as an attorney over the past 20 years of practice. We began as adversaries on the opposite ends of the table. And over the course of our professional relationship, we became very good friends. And this all began with my days of legal services. Later in private practice, Attorney Angelini reached out to me and asked me to co-counsel with him a case in federal district court against the United States government, which was a pleasure to kind of work with him and some of the other lawyers involved in that case. And I wish he had been here today, but he is here in spirit. He always provided me with advice, insight, and wisdom throughout the course of my career. As many of you may or may not know, I was born in the Republic of Chile during a time of great political upheaval. My father was a political refugee and came to the United States in the 1970s when I was just a child. But I was old enough at that stage in my life to witness what tyranny and lawlessness can actually do to common people. I still carry memories of those days to this day, and they're always with me in whatever it is that I do. Throughout the course of my professional career, my parents, along with my family, have helped me keep this experience in perspective. They've instilled in me and my sisters a sense of duty and service to others who are less fortunate than ourselves, regardless of our own position in life. My parents have exemplified strength of character, rising others up even when they had little to offer. I witnessed this firsthand. They taught me about empathy and humility, and also about work ethic and being able to accept praise for a job well done. I watched my parents toil for justice and fairness, navigating a society at that time that could be dismissive, could be demeaning, and at times could be exclusive. And I also saw a great deal from my family providing material assistance and emotional support at a time as a child when we did not have much. I consider myself very lucky to grow up in the United States and have the opportunity to be here and serve, and potentially serve in this capacity if this council is so gracious enough to vote in favor of my nomination. During the course of my 20 years of an attorney, I have effectively and zealously represented parties, regardless of their legal station or their legal position. I have successfully represented professional racists and those who've been openly antagonistic toward me because of who they perceive me to be personally. I've been able to set aside my own personal biases, my own views, and represent clients to the best of my ability, all within the confines of the rules of professional responsibility. I have assisted individuals, business, municipalities, government agencies, and others in obtaining their legal objectives. And I've always relied on facts and law, not ideology, not passion, to make winning arguments in various forms. Empathy and fairness are the two qualities that I admire most in judges. I have marveled at how certain judges handle difficult situations without getting rattled. And I think many attorneys and judges would agree that serving or interacting with unrepresented parties can be some of the most challenging at times. Throughout the course of my career in housing court and other forums, I have encountered a large number of unrepresented litigants. And in the housing court is one of the few forums where an unrepresented litigant can actually beat you and put you through your paces. I've had to sometimes deal with litigants who are facing a great deal of money that is owed in rent, and I've always tried to treat each litigant with respect, with dignity, and with courtesy. Because my job in those situations is not to make them be antagonistic, but to work together to either form a legal objective or have the matter heard before trial. Maintaining decorum and a safe atmosphere in a courtroom is a specific art. It takes a great deal of patience to allow each party to address the court, balancing the need to maintain the docket flow while giving an equal voice to those who may not be able to express themselves well or present a case efficiently. Although each case is distinct and unique in its evolution and consistency, some sense of predictability is important to all litigants. I imagine that judges, like attorneys, need to dwell in a place of grace while reconciling the utter disappointment and sometimes anger of litigants who may be unhappy with a particular legal outcome. I've had to deal with this component professionally frequently in dealing with litigants in housing court. Thankfully, my career in housing court and other courts have given me the opportunity to handle many cases of varying degrees of legal merit on both sides. Regardless of my own client's legal positions, treating opposing parties with respect and dignity is important to me because losing one's home to foreclosure or eviction or their loss of freedom or enduring some other destabilizing crisis like the loss of income is a life-changing event. On top of that, the court can be a traumatizing, confusing process. Those with mental impairments are particularly vulnerable. The individual may be speaking in an emotionally charged manner or projecting hostility about the process in my direction. Sometimes I've had to represent litigants who are also behaving in that particular manner. It is important to allow these individuals to express their concerns, even though they may not be comfortable, relevant, or accurate. Every litigant has their own emotional truth, and we as professionals cannot always address or resolve that particular problem. This approach, whether in the hallway or remediation, has allowed me to effectively represent clients, both landlords and tenants of all types, zealously and fairly. I expect to bring this perspective to the bench, and I believe that my personal and professional experience will be uniquely valuable to the housing board if this council approves my nomination. I aim to be even-handedly and decide cases based on the merits, based on all credible evidence and application of the law, regardless of the litigant, regardless of their position. I will work with each party to feel like they were heard and given their due process. My hope is that everyone who appears can say that they were treated fairly, with dignity, respect, and compassion, and that they had an opportunity to say what they had to say in court. Judges are entrusted to help parties solve problems. Like any human endeavor, process is not perfect, and mistakes will be made. For this reason, it is important to remain humble and have faith in the process of appeal, always learning and adapting along the way. In addition, I am able to reflect on times when I sought a sympathetic, non-judgmental ear. I understand that everyone at some time needs to seek the benefit of what they hope is an open ear in order to get closure in a personal or professional situation. This introspection, along with the love of my family and friends, has kept me grounded in the reality that is the everyday, personal and professional life. I have never forgotten where I come from and the arduous road we traveled to get here. And to be here before this council, to me, is a great honor and privilege. As John Adams once said, to be good and to do good is all that we can do. That is what I hope to bring as an associate justice to the housing board. Thank you for consideration and support. Thank you.
Thank you. Council Juvenile.
Thank you. I was hoping you were gonna tell us something about what happened in the case of the convention. Tell us what happened. So let me ask you. First of all, what is the jurisdiction of the housing?
The housing board has jurisdiction under Mass General Law, Chapter 185, Section 3, I believe. C, the best of my knowledge. And the housing board deals with all landlord and housing related matters, all housing related matters, in its jurisdiction. So there's an enabling statute that states exactly what it is.
They do not have jurisdiction over the four families, is that correct?
That is correct. So if a litigant comes to the housing board for a trial with the issue of title, generally, there's two options that the person who wants to challenge title can do. They can either file the case in Superior Court, which is actually in Superior Court, which is fairly common practice, and then remove the housing court case to the Superior Court, or stay the proceedings in housing court, or ask the housing court to be designated a Superior Court, since it's a Superior Court level court, and ask I believe the Chief Justice of the trial courts gave what's called an interdepartmental assignment to have one housing court judge sit as a Superior Court judge, and that matter can be heard by one judge. That's the process.
Okay. And you've heard the words mentioned here, predatory lenders.
I have heard the term
What's
predatory.
your definition of a predatory lender?
I don't have the definition before me. That's the legal definition that's used. But my understanding of a predatory loan, as I recall from this case that was referenced, I believe the Sweeney case, which is over at this point over 3 years old, involves the terms of the loan and the payment and the maturation are considered to be unconscionable and charged to conscious, which means that at the time that the person is signing the loan, it can't possibly be applied for whatever reason.
So you did work for First Federal Credit Union.
I represented the Webster First Federal Credit Union with regard to the Sweeney case.
Do you consider that financial institution a predatory lender?
No, it's a credit union, so they operate under somewhat different regulations than, say, a bank. And the loans that are offered are generally not considered predatory in nature because under the terms of their charter, they can't provide certain mortgages under certain terms. But I, as the attorney that does the evictions, have nothing to do with how those mortgages are drafted, written, or issued, because I get hired only when there's a summary process case or litigation after the mortgage is written.
So if a bank or a credit union is issuing a mortgage, raises the value of the property and raises the applicant's income so that it would clear whatever rules and regulations are in that field, would that be predatory lending?
I think it would vary, and I'm not a predatory loan or predatory lending expert.
Okay, so let me get the chase up. Ms. Sweeney indicated that the bank, the credit union, put a very high value on her property and then used her salary of $6,000 a month. According to her, she's a part-time real estate agent. She had made $6,000 in one transaction selling a home. So it wasn't $6,000 a month, but she said they did that. Obviously, she accepted the loan because of that. Would that be all right to do something like that as a lender?
I can't speak to the lender because that's an.
No, I didn't ask you to speak to the lender. I just gave you the scenario based on Ms. Sweeney's affidavit and testimony that the bank raised the value of the house much more than it was worth, which then allowed the bank to give a higher mortgage, and then took her $6,000 check for one real estate transaction and put in the paperwork that she made $6,000 a month to cover. That would make her a good lender to cover the payments, wouldn't it?
I believe, based on my recollection of the case, that went forward through trial, that the loan as it was offered was called a 7-in-1 loan.
What does that mean?
It meant that the period of the loan would be at a fixed period for 7 years and then never go up or down anything more than 1.
Okay, but
Or 1%.
Come back to the point I made. If the First Federal Credit Union raises the value of the house on the loan documents and puts in that she's making $6,000 a month when she wasn't, would that be something that would be called predatory loan?
Again, I'm not a predatory loan expert, Counselor, I'm the Jubenville, but I believe that if the appraisal of the property is it's listed and that is in line with what the fair market value of the property is in that particular area at the time of the application.
You said something about the fair market value being about 240,000, the mortgage company or the bank, credit union indicated the property was worth somewhere in the area of 300,000+.
If the,
Do you think it's okay for a bank to do that? They got somebody coming in and want to refinance. By any kind of investigation, they would have realized that this isn't a good risk. But
well,
they raise the value of the house, so they can justify the mortgage. And then they indicate on the record she makes $72,000 a year when she only had one check for $6,000. Wouldn't that be improper to do that? If that happened,
if that happened, yes, I believe it would be a problem.
it would be a problem.
Yes, if it.
And when you were representing the First Federal Credit Union, is that the name of it, or is it Webster First?
That's the first federal credit.
Okay, when you were representing them, you did a lot of cases for them.
I've only handled 2 cases for them,
The Sweeney case,
yes.
and what's the other one?
The other case is a series of cases arising out of another property located in Shrewsbury.
Okay, so when you looked over, or did you look over the financial documents that Ms. Sweeney sent?
I did, I looked over the entire file that was provided by the legal office.
So when you looked over the entire file, did it strike you as funny that she was being okayed as somebody making $72,000 when she wasn't?
Based on what I recall seeing in the file several years ago, I believe that the mortgage that was given to her was appropriate because at the time, I believe she also had a store. She had a boutique for which she was also earning income in addition to the real estate transaction that she mentioned.
Do you agree with me that if she was making $72,000 a year, she probably wouldn't have been in that position, this position she was in the first place?
Most
She
likely,
would have been able to pay the mortgage, right?
most likely.
And it seems to me anyway that, we heard the testimony about foreclosures and losing your house, and it's got to be one of the most traumatizing events in somebody's life.
I would
So if
agree.
you're making 72,000, she's had that house for what? She had it for at least 20-something years or more. Why wouldn't she pay the mortgage if that's what she was making?
The facts as they came out of trial, Mr. Jubenville, was that the best memory was that the property was supposed to be leased out to the other family members.
Whatever, but they gave a mortgage based on her salary,
Yes.
and that salary wasn't true, wasn't.
Well, the salary that she listed was signed under the pays and penalties of perjury. So she listed that as her salary on the mortgage
So what?
application.
She wants a mortgage, right?
Yes, sir.
She died, she's starving for a mortgage. Was there a lawyer in the room when she did the passing?
Was there,
Did she have a lawyer?
at the closing?
Yeah.
I don't know, Council Jubenville, because I was not involved in that
Okay.
part of the
The
transaction.
lawyer usually does the closing for the bank. So he would have been aware of it.
Yes, and I believe she would have been entitled to her own lawyer as well.
That's right.
You met this lady a few times.
Miss Sweeney, we interacted in court several times and then one time at a coffee shop as it was referenced.
In court, but not in the court.
Well, in the hallway, while we were waiting for a case.
And she indicated in her filings that you made statements to her. Let me see if I have it. Can't. That she wasn't going to win. Did you tell her that?
No, I've never made any such statement to a litigant. I've been an attorney long enough to know that even though I'm an attorney, that a pro se litigant can and will make a very good legal argument. And Ms. Sweeney was a very good, worthy legal adversary. She was a very effective advocate for herself.
My question was to the point here. If you're going to be a judge, you got to listen and answer what the person's asking or saying. Did you ever say to her she wasn't going to win her case?
No.
Why do you think she put that in documents?
I can't speak to why she thinks that.
Did you ever threaten her?
No.
Email, you're aware of the email
Yes,
dated September 5th, 2019?
I'm aware that I wrote an email, but I was not aware that it was part of what I investigated here, so I don't have it in front of me.
Nobody brought this to your attention? Where did, yeah. Never been an opportunity.
He doesn't have
Who doesn't?
the nominee.
You gonna come? I don't.
Every happened, Counselor, yes.
That's all I can.
Have you read that?
Yes, I just read it, thank you.
Is that refresh your memory as to the, as to email you sent Ms. Sweeney on September 5th, Thursday of 2019 at 11:49?
Yes, it does.
Okay. So the email starts off with you saying you're memorializing the conversation on 9/5/19.
Yes,
What was that conversation?
I believe it was a conversation during Rule 9A to discuss the position that we had taken the position that the Superior Court can't overturn a decision of the Housing Board.
You say, I'm writing to inquire if you, your son, your daughter-in-law would agree to dismiss the cases with prejudice, correct?
Correct.
What does prejudice mean?
Means they can't relitigate the matter anymore.
This means that the case can never be brought back and you would be barred from litigating the issue, right? I inform you that in the case, that if the case does proceed, WFFCU, what's that?
What's the first federal review?
Would amend its answer to include an assessment of attorney's fees and costs pursuant to general laws, chapter 231, section 6F. That in there?
Yes.
Why would you put that in?
Well, I had consulted with my colleague who, because I was co-counseling this case with another lawyer, and we had discussed whether we should include that or not. Because the initial answer.
Well, my question is, why did you even put it in there at that point?
Just so Ms. Sweeney could be on notice that Webster First Federal Credit Union believed that her position was frivolous.
You heard the testimony here about chapter 231, section 6F.
Yes.
And Can the court order legal fees to be paid by a pro se litigant?
I believe it has to be finding, but I would have to go back and read the 236 F statute. The statute does reference an attorney, but sanctions can be issued if there's a finding of
Well, we just heard testimony from one of the witnesses that said that the Supreme Judicial Court ruled on that, said that a pro se litigant is not a lawyer, and the legal fees that you mentioned in 6F are against lawyers. Right?
Correct.
So that means they would not be applicable to Ms. Sweeney as a pro se.
That is correct.
So knowing that, why would you put that in there to Ms. Sweeney?
Because at that time, we were mistaken as to their applicability.
You have the email with you that you sent her indicating that you had made a mistake in that?
No, I do not.
Did you ever send one to her saying that we had made a mistake and there are no legal fees involved?
No. Well, because as the case proceeded, the court ruled that the Superior Court ruled that they would not overturn the decision of the housing court. And that the decision.
What's that got to do with sending her an email saying, hey, I don't want you to be upset about your paying legal fees, so I'll correct that, you were wrong, and now make your determination based on no legal fees involved. Just never do that.
It should have, and it's an omission. So.
Well, when you and your colleague wrote this and said 6F, which allows assessment of attorney's fees and costs, that was incorrect.
Correct.
Excuse me. And then you say, at this point, the case pending in the Superior Court is frivolous, and the Superior Court stated it will not reverse the judgment of the other courts, correct?
Correct.
Furthermore, the court does not have such authority, and no such legal authority exists in statute or case law.
That's correct.
As I understand the case, she filed in the Superior Court not an appeal of the housing court issue, but on a separate issue, which was the loan was null and void. Is it not why she filed in the Superior Court? She was creating a new reason to not have to pay or not have to get evicted. The fact that she was claiming that that mortgage, the lending and the mortgage was void.
I believe she was alleging in her initial filing, Council Giovanni, that the judgment of the housing court should be voided because of the mortgage issue.
Right, it's the new filing in the Superior Court was saying that process down in the housing court was null and void, and I'm bringing a new claim on a different matter before the Superior Court. Right?
Yes.
The Superior Court has no authority to take that new claim and deal with it.
At the time, the argument that we were making was that
No, I don't care about the argument. You indicated that the court has no such legal authority to exist in statute or case law. From sitting here, I have to say, that's not correct, is it?
well, it was
Is it or isn't it correct?
I believe that the court cannot overturn the decision of a housing court.
She didn't ask in the filings that they overturn. She said in the filings, I'm making a new complaint that the housing court, the bank's actions are null and void. I think it was over the 5-year wait. Is that the reason?
I don't recall the reason.
Okay, but the Superior Court can certainly take a new claim.
It
And
can
they can make a finding on it.
correct.
But you said they don't have any authority.
That's the legal position that I was taking, yes.
But that's not correct today, isn't it?
I disagree with, any court can take any filing, but the position is that they can't overturn the decision of another court, particularly the housing court.
Well, that's not, from what I'm reading and seeing, that was not the claim she made, to overturn the housing court. She said the housing, the credit union filing against me for the foreclosure is null and void. That had nothing to do with the housing court's decision, did it?
The filing of the complaint in Superior Court dealt with the request,
Voiding,
voiding the judgment of the housing court.
right, because they didn't have authority to take it. Right,
That was her opinion.
and you're telling me that the Superior Court doesn't have jurisdiction to look at that?
The matter has been litigated, yes, that would be my position, yes.
So why did you feel the need to tell her all of that? That the court has no jurisdiction in statute and case law? What was the purpose of that in this thing?
Just to memorialize what we discussed pursuant to Rule 9A.
We then go on to the second paragraph. As I have stated in court, you have done a great job defending and prosecuting your claims. To advance them knowing there no likelihood of success may result in a future dismissal/judgment against you and your family. Right?
Yes.
If that is the case, I will be authorized to move pursuant to 231, Section 6F for an assessment of reasonable attorney's fees and costs. So the second paragraph, you reiterated that you're moving for attorney's fees and costs if she doesn't sign a document.
Correct.
And you said you were sending, you're attaching copies of certain documents. If I do not have it by said time, I will serve a motion to dismiss. Would, excuse me?
I'm sorry.
If I do not have it by said time, I will serve a motion to dismiss, which you will have 10 days to respond and get me the original
Yes.
what?
Original position. A response to the whatever motion was served.
In the Superior Court, under the Superior Court rules, I may file my motion and your affirmative response. This process for motion practice is different in the Superior Court than the Housing Court, right?
Right.
Now, you said you didn't threaten her.
Correct.
If I'm in her position and I get this letter, I ask you this, if you're in her position and you get this letter, would you think that twice telling her that she's going to be responsible for attorney's fees could be taken as a threat?
Well, usually a threat, from my perspective, implies that it's going to be something more than just a legal consequence.
Well, the whole point of the memo is to get her and her two sons or daughter, son and daughter, to sign the document she sent, right?
Correct.
And you're trying to do that by telling her, oh, by the way, if you don't give me the documents right away, I'm going to move for the attorney's fees. Right?
Well, that we would move to amend the answer to include that claim.
Yeah. So you don't think that was taken as a threat from her? I gotta tell you, I would be. I would be if I wasn't a lawyer and I was down on my luck and I get that. I go, holy Jesus, I'm gonna, twice he said it, he must be serious about this. I better sign the documents or I'm gonna have to pay a lot of money. Isn't that what your intent was for this?
My intent was to resolve the case.
Was your intent to let her know it would cost her money in legal fees if she didn't sign those documents?
I don't recall what my intent was. My intent was to put on notice that we would move to amend the answer to include such a claim, which was in error.
Twice,
Correct. It was the same email.
twice,
Yes.
twice for sex work. In fact, one of them, she said, if I do not have it by said time, what was the time that was given?
I don't remember. I believe it was the end of the business day.
Okay, so the end of this day, if I don't have that in to him, oh my God, I'm gonna be paying legal fees, and he made a point to put it in 2 paragraphs, so I didn't miss it. Wasn't it the point of this thing? So get her to sign the damn documents,
The email speaks for
and
itself.
put the pressure on her that if she loses, she's gonna pay her legal fees. That was the whole point of this thing, wasn't it?
The email speaks for itself.
I want you to speak for it, you're going. I know how I would take it if I was her. Holy cow. I better sign the documents and put a cost me a lot of money. And that was your intent to get her to sign, threatening her with paying a lot of money, right?
I wanted the matter resolved.
You what?
I wanted the case resolved.
Right. And you were gonna make sure that you let her know if she didn't resolve it, there's some bad things coming down the pike, right? Right? But the bad things, you didn't have any authority to do.
In retrospect, it was a mistake.
A lot of the things you put in these 2 paragraphs, one could make the argument that you were giving her some legal advice. Correct?
I don't believe so.
Well, you say to her, you tell her that if she doesn't sign the documents, or if she does sign the document, she's to dismiss the case with, if they sign the document, the case is dismissed with prejudice. That's legal advice to her, isn't it?
I consider that provision to be information.
Yeah, but you don't represent her, right?
No.
So you agree with what's been said, there is a rule on what lawyers can do with proceeding defendants, correct?
That is correct.
Have you read what that is in your career?
I have read it from time to time, yes.
Okay. And, would you agree with me that the intent of the rule cited about contact should be limited to get a lawyer? Isn't that what it says? The rule.
It should, yes, it does. I don't have it in front of me, but I believe that you are correct in what it says.
So you didn't say that, and you didn't say, look, you talked about my name, but I'm going to suggest you get a lawyer because I don't feel comfortable telling you that you're going to lose, or telling you that we're going to assess legal fees. You went ahead and told her what's going to happen, what should happen, what she's going to be barred from any further litigation. And you have until the end of the day today, or we're going to assess your legal fees and costs. On the side, right?
That's what the email says.
That's pretty good advice, isn't it? That's legal advice. If you don't sign the documents, if you sign the documents, you're barred, it's perfect, it's barred. But it's dismissed with prejudice, and you can never bring it back. That's a legal, but that's what a lawyer would tell a client, right?
I think a lawyer would tell a client probably more information.
But they tell them that. If I'm in that field and I'm talking to her, I'm going to say to her, look, you sign that document, it's gone forever, with prejudice. Wouldn't that be her lawyer's job to tell them?
Yes,
So why did you tell them that?
Because throughout the course of litigation, Ms. Sweeney routinely asked me what was going to happen if X, Y, and Z happened. So if she asked me, I was trying to provide information to her.
Did
Sometimes
she ask you, what would happen if she signed the document?
about which one?
About the dismissal of prejudice?
Yes, and eventually when we did,
When did she ask you this?
we met at a coffee shop after she agreed to sign a dismissal without prejudice. Once she understood what that meant, she asked me to take that provision out, and I said, of course, I took it out. And the Superior Court matter was dismissed without prejudice.
Did you tell her anything when you met her at the coffee shop about the fact that she couldn't win the case if she was gonna lose?
No,
Was the coffee shop before this memo, email?
yeah, I believe that was during the eviction, and it was her decision she asked me to meet her there. I had asked her to meet her at the courthouse. She said she had something to do during the day, and if I could meet her at a coffee shop in the evening, which I did after consulting with a colleague.
Do you, after reading this memo, fresh in your mind with it, you had it to do over again, would you have sent this memo to her?
No, if I had to do it over, I would not send it.
Why?
Well, clearly, based on what I heard from the affidavit, I consider Ms. Sweeney to be an extremely resilient and tough litigant. And she was always extremely assertive, direct. And so she seemed to be she had strong fortitude. And so when we were dealing with each other, she would make very declarative statements about what she was going to do. And so I actually had the capacity to kind of understand the position that I was taking based on my interactions with her.
Yeah, but the question is, why did you say you wouldn't send this on hindsight?
Because based on what was said, you know, if a letter troubles somebody, it causes kind of emotional stress, even though you're trying to do your job, you know, that's not something I want to do to somebody. So I would probably rephrase the letter that I sent her if I were to do it over again regarding this particular
Well,
matter.
if you want to do it on hindsight, of course, you wouldn't have put in there that the court can assess attorney's fees and costs. If it's not trouble, you wouldn't have put that in, would you?
That is correct.
And that the court doesn't have authority, legal authority, doesn't exist in statute or case law. That would be incorrect too, you wouldn't put that.
I disagree with that legal opinion, but I can understand why somebody may disagree with my opinion.
By the way, some sort of a process was filed against you in the criminal side of the federal court system.
I've never been made aware of any law enforcement investigation by anybody at any time during my career.
Ever had any BPO complaints?
No.
Not one. Not even a letter from some client who's complaining. I know, I've been doing this 43 years and I've had, there's always some client who's not satisfied.
I can't recall a single complaint that someone has made to the BBO about me.
That's a lawyer's statement there. I don't recall. So there's two things that can happen when you say you don't recall. You could have received one and you forgot it, or you didn't get one. Which is,
I've never been informed, or I've never been called or told that there's a BBO complaint pending against me.
So back to the rule of professional conduct. You see why this rule is in effect for a lawyer to sit down with a pro se and give any kind of advice about the law where you represent the bank.
Yes, I
He's sort of in a vulnerable position with you as a lawyer. And
Yes.
you agree with that?
Yes.
She writes, that she was intimidated by you, including during the 2017 housing court eviction case. You approached her several times in the courthouse hallways, and we had several face-to-face meetings outside of court hearings. Is that correct?
I'm talking about Ms. Sweeney.
Yeah.
We met in the hallway a few times, usually it was, hi, how are you? We didn't really.
Okay, well, I didn't ask that. I just said, she says that you approached her several times in the courthouse, and we had several face-to-face meetings outside of the court hearings. Is that statement correct or not, your opinion?
Yeah, sure, I believe so.
Okay. Attorney, Carvajal, am I pronouncing it right?
Carvajal.
Said such things to me as, quote, you'll lose.
No,
Never said that.
no,
Attorney told me that if I had a jury trial, I would lose.
never told her that either.
He went on to explain how hard it was to write questions for each witness.
I said that we would have to do questions, that we would have to submit questions to the court for impaneling a jury.
He told me pro se defendants always lose jury trials because the jury does not want to be there, and they are mad at the defendant for keeping them there.
I never,
Never said that.
no,
He scared me into giving up my jury trial. Did she give up her jury trial
she waived her jury trial.
after talking to you?
No, I mailed her a copy of the jury waiver. And she was free to sign or not. Sign.
You didn't have any discussions about the waiver?
No, we did not.
How do you know she even understood what it meant? So on the times you went up to her in court and you had face-to-face discussions, what was the conversation, best you remember?
Well, the most memorable conversation I had with her was the day of trial. She handed me a binder full of all her exhibits that she was going to introduce, and when she was going to, if I objected to her binder being introduced as evidence, and I said, no, you can introduce whatever you want. And then we just conferred about agreed upon exhibits.
It also indicates that you indicated to her if she didn't agree, I'm putting a motion to dismiss with prejudice. And she said you indicated that if she didn't agree, and, quote, this is not a threat, quote, he was going to amend his previous motion so that we're going to have to pay all my legal fees, and that I, my disabled son John, and my daughter, disabled daughter Anne Marie, are going to have to pay them. You said that?
No,
Did you say, if she didn't sign it, you weren't making any threat that this was what was going to happen?
No.
Legal fees she was going to, no. Well, he did say she was going to pay legal fees, right?
I did in the Superior Court case email that's referenced from September 5th, yes,
You did tell her that twice in the email,
yes,
and that was to get her to sign, right?
yes.
So when she says that you said that she didn't agree to sign, and she said that you said, this is not a threat. In other words, this isn't a threat that I'm going to do the legal fees
For the jury trial?
for not signing the document to dismiss with prejudice.
Yes,
He said, I am not trying to threaten you. And then a little later, he'd say, I'm not trying to intimidate you. Did you make those statements to her at any time?
I generally don't make, I don't make statements like that to the leads.
Well, you just said earlier that you said it was not a threat, and you indicated about the legal.
I don't use the word threat or intimidate towards somebody. I'm not threatening, I'm not intimidating. I generally don't make those direct statements.
I don't care about generally, did you make them in this case?
No, I did not.
You have any idea when she'd say that about you?
I couldn't speculate as to Ms. Sweeney's intent as to why she would say something.
Okay, so I take this clearly as a threat. I don't think there's any other way you can take this email.
September 5th email?
Yeah, it's a threat, and it's letting you know that there's gonna be a heavy price to pay if you don't sign the document. That's what it says. And she says that you also indicated that you weren't making any threat to her, evidently it was a verbal conversation about this issue. And you said, I'm not making any threat against you.
Talking about the September 5th email?
Well, I'm talking about that, not the email itself, but the September 5th issue, the signing the dismissed with prejudice. You said, I'm not making any threats, but I'm going to move for attorney's.
I'm sorry, Mr. Counsel Jimmy Bell, I was confused. I thought you were referencing the jury waiver form
No,
earlier in the question.
talking about getting her to sign the motion to dismiss with prejudice. And you wanted her to agree on it. You told her she was going to pay legal fees if she didn't sign it by the end of the day. She also said, you said if she didn't agree and you felt that this is not a threat, he was going to amend the previous motion so that you are going to have to pay all my legal fees. Say that.
Wrote whatever's in the email, so
No, I'm not talking about the email, I'm talking about her saying you said that to her.
verbally? You repeat the question, I'm sorry, I'm trying to think.
You wanted her to sign a document to dismiss the case of prejudice.
Yes,
No question.
correct,
You told her that she was going to pay legal fees. No question.
correct.
She said, you also said the same thing, except you said you were not making the threat against her.
Yeah, I did not say that, yes, that part I did not say.
I'm not trying, and you said, I'm not trying to intimidate you, according to her. Did you say that?
I did not say that.
Did you read all the stuff that was sent to you, that was sent by, Attorney McKay?
Saw a letter. That's all I've seen.
Well, all these documents that we have were sent to Bob Ross in the governor's office.
Yeah,
Did he make them available to you?
I saw Miss McKee's letter.
Transcript.
I have not seen a transcript.
You didn't see 12 pages that Ms. McKee wrote?
I saw a 2-page letter or 4-page letter that she wrote.
I'm looking at the 12, number 12, which is the last page for submissions, and that all went to the governor's office. You're not aware of that?
I saw a letter dated in June, I believe, from Ms. McKee, and a letter dated in June from Grace Ross. If that is the document you're referring to, I saw it.
referring to the documents.
Excuse me, Should-
I have extra copies.
we're talking all these documents.
Right here.
Okay.
Oh, hold on.
Yeah.
Thank you.
See the first page there? The number one at the bottom,
Yes,
the memorandum, for Robert Ross,
yes,
and it's sent by Sarah McKee.
yes,
There's 12 pages there that she wrote, right?
that is correct.
Okay. So you never were given that?
I have not seen these documents.
Well, your original hearing was continued for quite some time.
Yes.
Why do you think that was continued?
I believe Ms. Devani, Council Devani had told me that she had concerns, and so she continued it.
Excuse me? What did I say?
That you were going to continue the initial hearing of June 9th.
The reason was because there was another council who had two. I was ready to put yours on, and a councilor had two nominees. And out of respect, I canceled mine and put it forward. So there really wasn't any, it's just a procedure. But you had talked to, to Lauren and people, and Bob Ross told me that you answered all the questions and they were very happy with you. So it isn't as if you didn't know this had happened. I'm sorry, I'm taking your time. I passed it, Judy.
Yeah. So you had the hearing date, it was continued. And in the meantime, there were a lot of things that went on. You were being advised or you were required in the governor's office at the wide. Your hearing was put off.
I was informed that it was postponed. That there was, I was given submissions, but not this expensive.
What were the issues you were told about?
The Sweeney issue. The Figueroa, that case. And then just, I believe yesterday, I was informed that Ms. Ewington and Mr. Jenkins.
So you were not aware of the allegations contained in Sarah McKee's 12-page report?
I was aware that she made the allegation that she testified to based on a letter that she sent back in June.
Did you ask to see the letter?
I did see the letter.
Okay, well, let's let him stay until July 5th.
I've not seen this document.
Did you ask anybody in the governor's office what the problem was, the allegations were?
No, my perspective on this was to just, since I had no say in or role in it, besides appearing, to just wait till I was given information and appear.
I gotta tell you, if I'm waiting for a judgeship and I've been nominated, I know all the nominees are walk on eggshells after they get the nomination. Am I gonna make it through the governor's council? Oh my God, what's gonna happen? I gotta prepare. And first gets booted off for, it's been about a month, I think now. And I would, if I'm you, I'm saying to anybody in the governor's office, what is the allegations? I wanna see them and I wanna answer them. You never read them.
But yet, I was aware of the allegations by Ms. McGee and Ms. Ross that were referenced regarding Ms. Sweeney based on the letters of June, which mirrored what were in those letters. The testimony mirrored what was in those June letters. But I have not seen this 12, 13 page document.
You never saw the 12 pages indicating a lot of the stuff I asked you about here? You see that about threats or intimidation?
I saw Ms. Sweeney's affidavit. I saw that. I had that.
Well, who gave you that?
I believe, I received that from Laura Patricia Green.
Okay. And did they sit down and go over this stuff with you and ask you about it? Because McKee is sending a letter to the governor saying your nomination should be withdrawn. That's pretty serious, Al. That's a pretty serious statement.
I believe after the first postponement, I came in and spoke
We don't,
with the Ms. Patricia Green.
anybody else?
I had a phone call with, Mr. Ross and Ms. Green as well.
Okay. And did they go over the things in McKee's
We went over the,
allegations?
Sweeney issue and the complaints that were being alleged by Ms. McKee and Ms. Ross.
But they never showed me the 12 pages from McKee.
I have not reviewed any of these
Okay.
July 5th, July 8th memo.
So Ms. Sweeney writes an affidavit under oath indicating that the loan, the appraisal came in at $345,000, which was twice as much of the loan, 160, that she was applying for. And she talks about the $6,000 being used as her income. You saw that, right?
I believe that's from her initial. Are you referring to Ms. Dolores Sweeney's affidavit?
Yeah, you read that, right?
Yes, I believe I received this initially.
So it talks about the amount of the loan, the $6,000. And indicates in paragraph 18, the fair market value of the house was $230,000. Outstanding principal was $158,000. Right?
What page are you on? Council, you think?
18, paragraph 18.
Okay.
If those figures are correct and she's correct, isn't that the definition of a predatory loan?
I don't believe that element in and of itself constitutes a predatory loan. I don't have the legal definition in front of me, but that at the time, we argued that the loan was not predatory.
Why do you think, why would the bank increase the value of the house?
I don't know if they increased the value of the house.
Isn't there debt to loan requirements in these institutions?
I guess so, but I don't specialize in mortgages and I don't do underwriting, so I don't know how that works.
All right, so on paragraph 28, you said that you said such things to me as you'll lose. He didn't want me to have a jury trial because he said he had done several, and he asked how many I had done. True or false?
False.
He went on to explain how difficult it was to write questions for each witness, suggested I go to some law library. True or false?
False.
He told me several times in several ways that this was a lost cause and I will lose, and the defendants always lose jury trials because the jury does not want to be there and they are mad and they're proceeding in there. True or false?
That is false.
At another time, I served him with the appeal information. He explained that I had no idea how difficult it is to write a brief for the appeals court. Carvajal.
That's false. Miss Sweeney served me with a public notice of appeal and slid it under my door, so I never spoke with her regarding an appeal.
Informing he knows lawyers who would not attend it.
False.
He went on how everything has to be exactly correct. In the precise format, it's very difficult to write true or false.
False.
He reminded me that I had lost on housing court and I was wasting my time, and then he really wanted to get this off his plate.
False.
My question to you is, and you may not know the answer, but why would a woman under oath make statements like that?
I don't know Miss Sweeney personally. I can't speak to what her intentions or what intent would be.
Would you deny those statements under oath?
I believe I'm under oath today.
Well, you're under oath. We don't have the authority to give an oath-taking thing. We have no way to punish it, so. I'm talking about writing that is signed under the pains and penalties of perjury.
So if I would deny those under oath, yes, I would deny the claims that she alleges that, yes.
I understand. I'm one kind of many documents here. I think this doesn't happen in we don't really get these documents. You know somebody named Christina McCarthy?
Yes.
Okay. Did you see the affidavit she wrote?
No.
Nobody showed it to you?
No.
I'm gonna give it to you to read, but.
Counselor, I did read 51 and 52, 50, 51 and 52 on that, just to let you know. When I was interviewing Sarah McKee.
He writes this affidavit, it's under the pains and penalties of perjury. Do you know why this was written, by the way?
I don't know. I've only.
It had to do with you, and it was dated July 5th of 2021.
I don't know what she alleges.
What interaction did you get up?
I represented a client who bought the property that was foreclosed and she claimed to have owned. And I withdrew from the case in May because it was pending in housing court.
Did you send her emails?
I did send her emails that were sent to discovery. Also discovery.
Thank you. You still have those emails?
I don't have them with me.
No, can you get them to us? She says, that you went forward with the hearing. Acting like he had not been notified that I did not know where or when or how. That not only I need to show up, also with enough notice for me to subpoena my witnesses, so he's making an allegation that you went forward with the hearing, she didn't have enough time to get our witnesses there present. Do you recall that?
I believe we had court in that case about 3 times before I withdrew. The first time, Ms. McCarthy filed a motion for a late answer, which I objected to. And she asked for discovery, which I objected to, and the judge allowed reschedule.
We did, they suggested a bathroom break.
Councilor Trumanville, can I interrupt? I'm going to have a 5-minute bathroom break now.
Thank you.
Excuse.
Counselor Jubilo.
Did you read that affidavit of Christine McCarthy?
If I could just, it was just left on the, if I could just quickly.
Okay, well, let's continue this. He writes it on paragraph 49. So you set her up to be evicted because I would not have the right lawyer to contact at the last minute with a bankruptcy automatic stay like I believe what to do.
Are we on the affidavit of Christina McCarthy?
Yeah, paragraph 49.
Oh, okay.
Number 50, she says, these are underhanded, dishonest, dirty tricks. Our judges are supposed to be worthy of respect, even-handed, moral, and decent people. Right? I argue with it. Right?
I see this.
That's a pretty serious allegation against you. Can you explain to me this, as to why she would put that in a document under oath?
I can't speak as to her. I filed my notice of withdrawal.
This is before this is about some hearing that you had, and she wasn't given notice until the last minute.
I don't
Is that
send,
why she's saying that you set her up?
I don't send the notices of hearings. Those are sent by the court. And I don't believe I ever got an email or a phone call from this particular person asking me about anything.
Okay, I'm gonna let you sum up by saying this to you. There's a lot of people that made allegations against you here today in person and in documents. You're asking us to give you a job that's paying about $180,000 a year. And you'll have authority over people that come into the housing court. Tell me how I can do that with these allegations.
Well, I have always been, with the exception of the email that you referenced, I've done my best throughout my career to be honest and direct with people. I cannot speak as to this particular individual, but if anybody comes before me, I will be fair and impartial. If they claim they didn't receive something, I will look into it and see that they got notice so they can have the appropriate hearing.
So last question, the email that we spoke of, would you agree with me that that email was included in it threats for Ms. Sweeney to sign those documents?
No.
Okay, thank you. Thank you.
Thank you. Before I call the next one, I just want to just correct something while it's on my mind. Councilor Jubilo. Councilor Jubilo asked you if you had talked to, Bob Ross and so forth. I know absolutely sure. The day that I had to postpone the hearing, you came into the State House and you met with Councilor Green. And Bob Ross told me that you answered questions and that you said to him, I'll have no problem answering those questions. Now, I'm going to divulge something now. I went to him, probably just, to save you any embarrassment. I didn't have the document from Sarah or, some other things, but I got a lot of things from people out there that were hurt. and they were afraid, they feared you, they did not want to come, because they figured the council's gonna vote yes, and they'll be really in deep trouble. So I asked that the governor withdraw your nomination to save face. And Bob Ross told you that, but you did not say that here. You never said that here. That's why you talked to him. And Councilor Jubenville was asking you specifically who you talked to, what was said. So I want to say that. But Sarah later sent, well, she sent to Bob Ross, legal counsel, to withdraw your, asking the governor into her, and she sent to the JNC, and then later she sent to all of us. So I assume, that, you know, that when I gave things to Bob, that Bob, because he talked to you, that he was going to give that to you. So you didn't need that. You heard what she said today. And that's all. I just wanted to intercept that because I'm the facilitator. I talk last, and this is not the norm. But I just wanted to correct right here and there that you're not factual. And maybe you don't remember, but I remember that day and we canceled the hearing and you were in the State House. So that's all I have to say. I'm calling you Councilor Iannello.
Thank you very much, Madam Chairperson. It seems to me that a lot of these documents, it was like a pile more than that, you were not made aware of them before today. Is that correct?
That is correct.
And obviously, the councilors had them, obviously the governor's office had them, and for whatever reason, you didn't get them. How do you think you're doing so far today?
Well, I think I'm doing okay. I mean, I'm trying to remember some of these cases to the best of my memory.
Like when you say, okay, you know, I have 4 kids. How'd you do on the test? I did okay. That to me means, well, I think she got like a C+, B- at most. Do you think you could have been better prepared today?
If I had had these documents, then yes, I would have been able to better answer.
I'm sorry. Do you think you could have been better prepared today? Sorry about that.
Yes, if I had these documents that were just provided, then yes, I would have been better able prepared to answer some of these questions.
Do you think you need more time to go over these documents, or you don't think, Councilor Jubenville was very thorough, I gotta give him credit for that. But I want to afford you as much time, do you think, would you like, I mean, it's not up to me, it's up to the chairperson, would you like more time, like in other words, another hearing next week, so you can go over that, or you feel comfortable?
I'm comfortable proceeding today.
Okay,
As a chair, I would not approve that, I'm sorry.
okay, well, that's okay, I just asked him what his
As a
opinion
district
was.
councilor.
I was just asking what his opinion was.
This has gone on for well
Excuse
over
me,
a month.
excuse me, excuse me. I didn't suggest it, I just asked. Yeah, Councilor Jubenville was very thorough, and any questions I might have asked you, he's asked you. So at this point, I do not have any questions. Thank you.
Thank you, Councilor. Councilor DePaul.
Thank you. Good afternoon, Attorney.
Good afternoon, Councilor DePaul.
So we've heard a lot today, and I'm not interested in rehashing things that have been already discussed. We have heard allegations that I think are worth taking seriously. I think Councilor Jubenville had a good line of questioning, but so beyond all that's been discussed, I want to make sure I have a good feel for who you are outside of these particular instances in the big picture. So I wanted to just ask you a couple questions about some of your experience that is unrelated to the things.
Sorry.
So first of all, when you left law school, you went to work for the Legal Assistance Corp of Central Mass.
That is correct.
Which is now known as Community Legal Aid.
Yes.
Why did you make that decision?
Because at the time that I graduated, I wanted to help people who I thought needed representation. I had done clinical work in law school, and I had represented criminal defendants in Somerville District Court as a voluntary defender with the Suffolk University Law School. I really enjoyed that part of lawyering.
What did you enjoy about that?
Well, one, it wasn't being in class all day.
Fair enough.
Second, it was,
Like
very,
Counselor Ryan, I know it's children pride.
second, it
I'm
was.
joking, Counselor Ryan.
It allowed me to take a lot of the theory that we're taught in law school and put it to practical application.
Did you get wealthy working at Legal Assistance Corps of Central Mass?
No. But it was a wonderful experience. I learned a great deal working at legal services. They're wonderful colleagues and they provide an invaluable service.
Let me ask you, you also were the regional coordinator for the mental health panel of CPCS, the Committee for Public Counsel Services.
That is correct.
When in your career were you in that role?
I was asked to apply for that position a little over a year ago. I've done a great deal of litigation in probate court with mentally ill litigants who are refusing certain medical treatment. I've done a great deal of litigation at Bridgewater State Hospital representing people who have been found not competent to stand trial, civil commitments, and also in the Worcester Recovery Center and Hospital. And so they were looking for someone who was based in Worcester who would be able to provide implementation of policy and support and oversight to the guardianship and civil commitment panels in the county.
Okay, so you were sought for your expertise and your experience in this particular area. Is that fair to say? So one thing that concerns me in all our courts, and I believe I brought this up to you when we had a chance to speak ahead of your hearing, is that especially pro se litigants, but folks who are in court are usually facing some kind of traumatic life event, right? And so even someone not coping with mental illness is potentially going to be dysregulated in their behavior. And so I'm wondering, what would be your threshold for holding a pro se litigant in contempt? If I could put a finer point on it, a case that I often refer to, which of course is not relevant to housing court, is a case in juvenile court that the SJC recently overturned, where a 16-year-old female was held in contempt for telling off the judge. So as an analogous situation with a pro se litigant potentially, actually whether or not they're represented, facing eviction, facing foreclosure, whatever it may be, I imagine they may be in a poor mental state, right? A distraught mental state. What would be your threshold for holding someone in contempt?
Well, I believe that they would have to be put on notice of whatever the violation is and then served with a summons and brought back for an evidentiary hearing to determine whether the level rises to that. There are routinely in all the courts and in the housing court, litigants do lash out at the courts. But most judges that I admire and respect show a great deal of restraint in dealing with litigants who are undergoing traumatic events. And sometimes the best way to diffuse a situation is to let the person have their say and let them walk out.
Do you feel you possess that restraint and that level of patience and empathy for what's going on in the courtroom?
I believe I do.
I had a chance to speak with the executive director of Community Legal Aid for Central and Western Mass, who was a colleague of yours when you were there. Is that accurate, or a supervisor?
He was my supervisor.
Okay. He had only exemplary things to say about your handling of the most vulnerable folks who were seeking services. He definitely pointed out your experience working and addressing mental health concerns in the justice system. We heard Counselor Ferreira brought up a particular case that you worked on regarding a young man who needed to access their house.
Yes.
Could you tell me what you think the difference would be? I heard a lot, the situations we heard described today. In every instance, whatever the outcome was, you had a role as a zealous advocate for your client, which I understand. Could you explain how you would articulate the different perspective you would take as a potential housing court judge versus being an advocate, whether plaintiff or defendant?
Well, I believe the judicial guidelines on self-represented litigants provide a pretty good kind of roadmap as to what a judge should do in those situations. And one is to be really open and fair, explain the process, tell the litigants that only admissible evidence will be admitted, that every self-represented litigant, is proceeding as if they were an attorney themselves, and give everybody their right to due process. So I think as a judge, your job is not to really do the bidding of one side or the other. It's to hear the evidence, make credibility findings, and apply the law as you interpret it.
Since you've been in private practice, you've had occasion to provide pro bono services at Community Legal Aid?
I have provided, yes, amongst other places, yes.
So I volunteered for Community Legal Aid in education law, and I know in education law at the time when I was doing that, there was a dire need for folks to step in for that. Is it similar in housing?
Yeah, as Ms. Ross indicated during her testimony, there is a need for lawyers who are knowledgeable and skilled in the certain areas of law that regularly appear in the housing court. And there is a lawyer for the day program, but as was provided earlier, it's not as thorough as some people would want it to be. It is available on certain days, although during the COVID crisis, the courts did set up both a landlord and tenant lawyer for the day to provide that lawyers could volunteer for and provide pro bono service for 3-hour shift.
Okay. We've had copious documents. Many of them have been discussed. The matters, I think, are serious. They have been addressed here. I appreciate your time, and I have no further questions.
Thank you.
Thank you, Counselor. Counselor Duff, any questions?
Yeah, I do, thank you. I actually was hoping Councilor Bill would hear some of this, because I work in the real estate industry, and these issues that have been brought up are indeed very, very serious. There are also issues that I am professionally and emphasis on, intricately involved with, and know probably more about them than anybody else in this chamber. To get a loan, you have to, whether it is with a bank or a credit union. I know Councilor Devaney is not interested in this because she doesn't think people should have to take classes, but I do. That you have to provide your tax returns. So you can't just say you make $6,000. Yeah, you have to provide legal documentation, and it is your federal tax returns. In fact, it's 2 years of tax returns to even get a mortgage. Credit unions hold their applicants to an even higher standard. That said, credit unions are also much easier to renegotiate with them, unlike what that fellow did when he was with Bank of America. A credit union, you can actually walk into and find a person and have a conversation. Now, I've done quite a bit of research because I have, as a realtor, access to a lot of these documents. Miss Sweeney's loan was absolutely not a predatory loan. There is no evidence in any of these legal documents that it was. What Miss Sweeney did, however, is she kept taking money out on her house. And in the business, you know, we refer to this almost like they're using their house like a personal bank account or an ATM. That's what she did. In 1997, her original loan was $25,000. 3 years later, she took out more. 2 years later, she took out more. 2 years later, she took out more. Then she went up two more years after that, when the rates dropped significantly up to $160,000. This was not a predatory loan because the value of this house, which sits on a quarter acre of land, it's a 4-bedroom, 1.5 bath house, 2,700 square feet, was worth well more than what the bank loaned her. In fact, it was probably worth about 300,000. But they put the assessment around, from what I can see in the records, probably about 235. So this representation, Council Dukenville, I really did want you to hear this because I was saying how I've done the research on this loan. This was under no circumstances a predatory loan. She kept taking money out on her rolling board, providing federal tax returns. Providing federal tax returns under pain of perjury. In the real estate industry, that is fraud. That's something you go to prison for, not jail. You go to prison for that. That is a very, very serious thing. So if she was lying to the credit union, she has committed a serious crime. If she wasn't lying to the credit union,